17.
Yes, ma'am. I have taken suggestion from the other side. After 3 weeks, ma'am.
Oh, see, this is the 18 matters, 2018 matters.
Others, ma'am, 2 weeks.
Why you need adjournment? This is the 18 matters. What is the difficulty on Mr. Pange? What difficulty he is facing? After 2 weeks, on the request made by the London Council for the petitioner, list the matter accordingly after 2 weeks, and on a date to be filled by the registry, and the both the parties are hereby directed to proceed with the hearing on the next date without delay. Okay.
All right. Your Lordship, I'd like to mention item number 11. I, on behalf of Planet Council T Tang, due to some personal issues, he is currently out of station. So, and affidavit in opposition is yet to be filed, Your Lordship. Affidavit in opposition yet to be filed. So matter may be deferred for 3 weeks.
List after 4 weeks, enabling the
May I, my lord?
enabling the respondent to file the affidavit in opposition.
Lordship, I'm for the petitioner in this matter, so there is a interim that may be continued.
Interim prayer or interim order was there?
Interim order.
Interim order be continued till next day.
Obliged. Much obliged.
Number? What that is? 18. Oh, Mr. You have arrived today only?
My lord,
Today you have?
last evening.
Last evening.
By road, it has become very easy nowadays.
Yes, yes.
5 hours it can become.
Yes, yes. 5 hours.
Lordships with the escort and all can come even earlier. We take 5 to 6 hours to reach.
Yes.
Now, in this case, I have challenged an order passed by the trial court in a civil suit, whereby the two preliminary issues, one of non-joinder of necessary party, and the other rejection of plaint on the ground of non-disclosure of cause of action against the two defendants. Both the issues were decided against me, as against that I have come before Lordship. Just in a nutshell, before I go to the documents, I give you Lordship the picture. A plot of land was acquired by the government of India for construction of a road. Now, two subclans, Jensen and Jegdu, are the subclans of a Sajik clan, main clan. Now, the entire land belongs to the Sajik community. The community has given the land, their land was acquired for the purpose of construction of the road. Now, the amount of compensation that was given to them individual responsibility. It is the responsibility of the society. Either you make all the members of the society as a party defendant, or you make the society itself as a party defendant. And accordingly, an issue was framed that suit is bad for non-joint of necessary parties. Now, the finding of the trial court is that the two defendants will be deemed to be representing the entire society. So this deeming,
The suit was any representative character?
no, your Lordship is absolutely correct. If the suit is filed in a representative character, then it's all right. Plaintiff doesn't say that the suit is filed in the as against the defendant in the representative character. Plaintiff can represent a good number of people. Plaintiff cannot say the defendant will be representing the entire society unless they make all the members of the society party or the society as a whole as a party. Now, Lordship will kindly turn to page, I'll show the agreement first, page 27. This is the agreement, deed of agreement. This deed of agreement is made on 19th of December 2020 in between Sri so-and-so, BJP ZPM candidates and Sri so-and-so, Tashing Jenpen so-and-so. The following terms and conditions are hereby agreed with both the parties. Number one, that is, Lordship will kindly note, the Saji society consisting of both Jendu and Jenpen, these are two subplans. Lordship has got serial number one. Saji society, Jendu and Jenpen shall pay rupees 20 lakhs to Sri Tashing Jenpen, he is the plaintiff, from the compensation amount of the so-and-so highway road. And clause 5 is important next. That Sri Bogam Jenpen, who is actually defendant number one, and Tashing Jenpen, who is plaintiff, shall maintain a cordial relationship between them. So the amount of 20 lakhs will be paid by the society, and this is subject to 3-4 conditions. Condition number 5 is he has to maintain a good relationship with plaintiff number one. Now, Lordship will kindly turn to the complaint filed by them. Jenpen scheme alone. It's at page 16. The person who is to get these 20 lakhs, he has filed this suit. Now his name is there as Tashing Jenpen. Now, Lordship will kindly see the parties. Next page. Only Tagam Jenpen and Tashi Yujen, two parties. Society is not a party. Members of the society are also not a party. Now, there is another issue, I'll come to that later on. Now, when we file the application for rejection of the claim, court said, no, we'll frame preliminary issue and we'll decide the preliminary issue. Accordingly, the court has done court 67, you may kindly see. Before that, Your Honor, I'll just take your Lordship to page 41 once. Page 40. and 40. The preliminary issue objection mentioned here. 39 and 40.
Three preliminary issues are being framed.
Yes. Lordship has seen. Number one is whether the suit is bad for non-gender party. And 2 is not important here. Number 3, whether suit is liable to be rejected for no cause of action as per order and rule 11. Now, this has been decided by the impugn order, which starts from page 67. But then operative part, it's a long order. I'll show from page 74 where the finding of the court is recorded. Entire order is based on presumption.
Operative part is page 70.
Page 74, Lordship.
Yes.
Yes. The second paragraph, Lordship, I have considered the rivals' arguments and taken myself through the material on records as well as judgment relied upon by the parties. From reading of paragraph 5 of the plain and also annexure 2, agreement dated 1912 to 2020, which I have read, annexed with the plain, what is imperative is that agreed amount of rupees 20 lakhs was to be paid by Saji society. from the compensation amount of so and so. And in consequence thereof, agreement dated 19/12/2020 was executed between plaintiff and defendant number 1. Defendant number 2, though not party to the agreement, had made payment of rupees 4 lakhs for and on behalf of Jendu clan, who is part of Saji society. Thus, considering the acts of defendant number 2, though he is not party to the agreement, however, implied to be party to the agreement. Then this is a presumption on the part of the court. Now I'm proceeding further. And since defendant number 1 was representing the Saji society as an authorized representative, now he cannot say, plaintiff cannot say that the defendant is representative. Plaintiff can say, I am representing the whole thing if I am authorized, if I can show an authority letter. But plaintiff cannot say the defendant is or representing the entire society. But the court is presuming that since defendant number 1 was representing the Saji society as an authorized representative, it is nowhere in the record. This court is in conformity with the submission of advance primary learned so and so for the plaintiff that since Saji society is not a registered society, as such, Saji society has no legal entity to be imputed as party to the suit. And since defendant number 1 has pledged on behalf of Saji society to pay an amount of so and so to the plaintiff, as such, it is held that Saji society is duly represented. It is a presumption on the part of the court. Further, from para 6 of the plaintiff had pleaded that amount was apportioned between Jendu and Jenpen clan at the rate of rupees 10 lakhs each. And defendant number 2 on behalf of Jendu clan had paid 4 lakhs in consequence of agreement dated so and so to the plaintiff. Though the remaining amount of rupees 6 lakhs was denied to be paid to the plaintiff, taking plea that plaintiff is not maintaining cordial relationship with defendant number 1, thus, considering the factual aspects as discussed and also from the resolution dated 2/6/2023, what is transpires is that there seems implied consent. These are all presumptions on the part of the court. Implied consent that Saji society, though through the defendant number 1 and 2 had agreed to pay an amount of his expense to the plaintiff, and since both defendant number 1 and 2 are from Jempen and Jendu clan respectively, and combined of Jendu and Jempen clan is Saji society. Thus, in my considered view, Saji society is duly represented, and the present suit cannot be considered to be bad for non-joint of necessary party to be liable to be dismissed. Moreover, Order 1 and another finding. Moreover, Order 1, Rule 9 CPC provides that no suit should be defeated by reason of non-joint of a necessary party. This I'll show from the Order 1, Rule 9 is not correct. And then next page was page 77. Before that, I go to CPC. As discussed in para 77, bottom paragraph here, as discussed in foregoing paragraph that though defendant number 1 and 2 Saji society had agreed to pay rupees 20 lakhs to the plaintiff in consequence of which agreement dated so and so was executed, and pursuant to agreement, defendant number 2 had made payment of rupees 4 lakhs. However, the remaining amount of 6 lakhs has been denied to be paid for violation of other terms of the agreement. Defendant number 1, on the other hand, had not made any payment as per agreement. Further, going by replication, what it transpires is that plaintiff was agreed to be paid 20 lakhs for his role to mediate the dispute between Jendu and Jendu clan society. And since both the defendants having failed to pay the promised amount, as such, there is actionable claim against both the defendants. Thus, in my considered view, plain cannot be rejected for no cause of action as per Order 7, Rule 11 CPC. Thus, both the issues are decided in favor of the plaintiff and against the defendants. Now, interestingly, the same plaintiff has filed another suit claiming these 20 lakhs that also have annexed, and that is per state on a different count. Page 41. This suit he has filed along with others. And his name is there at page 46 as plaintiff number 29. So he is claiming this amount twice. Page 46, serial number 29 is his name. Same day, he filed 2 suits. And here, not only he, defendant number 29 is the plaintiff and 30 is plaintiff's son. So, now page 54, I am showing just that same amount he is claiming. Page 54, Lordship will find paragraph 15. that the plaintiffs beg to submit that out of 76 households of Jensen clan, only 31 members are before this on the court. The total amount accrued to the 31 plaintiff is rupees 20.32 crore lakhs. So the same 20 lakhs he is paying in two different suits. There's a different issue to be decided in the trial. I'm not on that before. I'm just showing his bona fide. And now the issue before your lordship is that if the necessary party is not implemented, whether the suit can be dismissed or not. The finding of the trial court is that even if necessary party is not implemented, suit cannot be dismissed. Order 1, Rule 9 was referred. I'm reading Order 1, CPC Court of Legal. Kindly, if it is by Law and Justice book, page 85, Order 1, Rule 9.
Order 1, Rule 9.
9. Order 9, Order 1, Rule 9 says misjoinder and non-joinder. No suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interests of the parties actually before it. Till now it's all right. Now this proviso. Provided that nothing in this rule shall apply to non-joinder of necessary party. That means suit will not be bad for non-joinder or misjoinder of a party. But if the party is a necessary party, then the suit will be fatal. Now, for that, I am relying on a judgment. Paragraph 15. Paragraph 15, Lord, will kindly see. At page 423. A necessary party is a person who ought to be joined as a party and in whose absence no effective decree could be passed at all by the court. If necessary party is not imputed, the suit itself is liable to be dismissed. Now, there is a judgment of our High Court Lordship. Very recently, it was passed by the Honorable Justice Sanjay Kumar Mehdi. Relying on that 1963 Supreme Court, that is the first case about necessary party, the Lordship is aware of that. Para 17, Lordship will kindly see that reliance was placed on that 63 Supreme Court judgment, which is the first case on the concept of necessary party, proper party, and what happens if necessary parties are not included. Para 17. Your Lordship is aware of this Udit Narayan Singh Malpari's judgment. I am referring to actually paragraph 18 and 19, just the previous page, Lordship. This is a judgment by our High Court very recently on September 2023. Para 18, Lordship will kindly see. I am reading from the subparagraph relying on the Pramod Kalita judgment, para 12, under para 18. One must bear in mind the difference between non-joinder of necessary party and non-joinder of party. Order 1, Rule 9 CPC provides that no suit shall be defeated by reason of misjoinder or non-joinder parties, and the court may in every suit deal with the matter on controversy so far as regards rights and interests of the parties actually before it. Therefore, mere non-joinder or misjoinder of party is not fatal. What is fatal is the non-joinder of necessary parties, and the necessary party is one without whom an effective decree cannot be passed, or without whom the suit cannot be legally proceed. Thus, it is not the absence of the non-joinder party, rather the inability of the court to decide the dispute effectively. Therefore, whether a party is necessary party or a mere formal party has to be looked into from the point of view of the court's ability to decide the list effectively, and not from the point of view of the party. When the court is in a position to decide the dispute or right of the parties effectively without the presence of a party or parties, those as party may be a formal party, the suit cannot be held to be bad for non-joinder such parties. In view of the above, and then finding the court. Now, in our case, Lordship, I have shown from the agreement. The agreement is very clear. The society will pay 20 lakhs. Now, supposing today's society doesn't pay, you file the suit only against two of them. Can you get a decree? Can the court decide in the absence of the other members of the society? Court is recording a finding that the counsel for the other side has said, no, Saji society is not a registered society, so it need not be made a party. Very well. If it is not registered society, and if it cannot be or need not be made a party, at least members, all the members should be before the court to contest the case, because once the decree is passed, can the decree of 20 lakhs be executed among the two of them? It cannot be executed. That is why this one court has said, relying on that Pramod Kalita's judgment, that no, it has to be seen from the point of view of ability of the court to execute the decree. Now, if the decree of 20 lakhs is passed against two of the members, this decree cannot be executed. So that is why they are necessary party. And if the necessary party is not there, Supreme Court is very clear from the 1960 Supreme Court that suit will be liable to be dismissed. So this point was not clear, properly decided. Court has presumed certain things. No, I am presuming that they are representing the society. Who says? Nobody's case. Neither plaintiff's case nor defendant's case that the entire society is represented by one of the defendants. So in that way, the matter suit is bad for non-joint necessary party. That is my survey.
How many respondents are here? Respondents, how many respondents?
Pardon.
No, in your petition, how many respondents are there?
Only one. Plaintiff is the only person. Only plaintiff. Plaintiff alone has filed against two of the defendants without impeding all the members of the society or the society. That is my case.
Okay.
And he has filed two suits. In both the suits, he is claiming 20 lakhs. In one suit for himself and in other suit for himself and another suit for son. So he will get 60 lakhs out of 20 lakhs of his claim. And so far as the other suit is concerned, Lordship, I'm just informing this on court. That suit he has filed as a summary suit to get the matter very early. We filed an application that this cannot be a summary suit because what is his claim that is not determined. Unless there is a determination, there can be a summary suit. CPC is very clear. That was also rejected. We came before your Lordship, this Honorable Court admitted and granted a stay of further proceedings that the suit also.
Yes.
That is also a state.
So now here, after preliminary discussion or preliminary issues have been decided.
Yes.
What was the outcome of the result?
Outcome is now the suit will proceed against me.
Now the suit is still proceeding.
Proceeding. So further proceedings has to be stayed, Your Lordship. Last page, Your Lordship. Case shall be decided again on so for issuing document. So the case is proceeding. Court cannot execute this decree, Lordship. How can the court execute the decree when his claim is against this society consisting of so many members and decree is against only two of them?
Heard Mr. D. Mujumdar, the learned senior counsel for the presenting the petition. This is an application under section 115 of CPC against the impound order dated 8/1/2024 filed by learned civil judge Alur, West District. Wherein the maintainability of the suit, where the preliminary issues have been raised by the defendants / petitioners on the maintainability of the suit, money suit number 37 of 2023.
On the ground of non-joint necessary party.
It is submitted by the learned counsel, senior counsel, Mr. D. Mujumdar, that they raised the issue that this is a suit for that jointer and non-jointer necessary parties, and accordingly, the learned court below framed 3 preliminary issues. Those are the preliminary issues are in para
Page 39. Page 39.
39.
Page 39.
Accordingly, the learned court below framed 3 preliminary issues. Number one, whether the suit is bad for non-joinder of necessary parties as per Order 110 CPC. Number two, whether the suit is barred by res sub judice as per Section 10 of CPC. If you have any objection, you can go through up to page 39, 39.
Page 39.
And whether the suit is liable to be rejected for no cause of action as per Order 7 Rule 11 of CPC. It is submitted by the Learned Council, Mr. Majumdar, that there was an agreement between
The plaintiff and the society. Agreement is at page
Page?
27.
20.
7.
Between between plaintiff and Saji Society, wherein it was decided that wherein it was agreed that the petitioner number one, he is the petitioner number one.
Plaintiff is the person who is to get 20 lakhs.
Yes, but you are to no, as per the agreement.
Yes, society is to pay
So
20 lakhs to the plaintiff.
And as per the agreement, the society is to pay rupees 20 lakhs to the respondent. And there was another term in the agreement that there will be the present respondent and the petitioner. You are the petitioner number one.
Yes.
Petitioner number one will maintain a cordial relationship between them. Thereafter, and 20 lakhs. However, on the pursuant to that agreement, respondent number, petitioner number two, paid already paid rupees 4 lakhs on behalf of this society,
Saji Society.
Saji Society, and seeking the other remaining amount of money for the it is a respondent by that suit. No, sorry, money suit bearing number 37 2023. Wherein both the petitioners were made party as a dependent respondent.
Society was not made a part.
But Christopher, the society, now the society, all the members of the society were made party in this case, and for which reason, and for which the plaintiff raised, the dependent respondent raised the issue of non-maintainability of the suit due to non-gender / misgender of the necessary parties, on the basis of which the preliminary issues have been framed by the court, but the learned court below decided those preliminary issues only on presumption, and considered that the society is not a registered society. It has no legal identity, and hence the suit cannot be considered to be that non-gender or misgender of the society. And also considered and also framed the opinion that the suit cannot be defeated or dismissed only due to non-gender / misgender of necessary parties. Of section Order 1 Rule 9 is very clear. Then when the suit cannot
Necessary parties got impeded, so this
if the negative party is impeded, the suit is liable to be dismissed. And in that context, we also relied on the decision of Honorable Apex Court, quoted in 2010 7 SCC page 417. Mumbai International Airport Private Limited versus Sunis. You see the and they also relied another decision of about this court passed in on 2020, reported in 2023, Supreme GAU Law 1066 passed by this court, wherein also the learned Apex Court as well as this court expressed the view that suit is liable to be dismissed in absence of the necessary parties in under if the court that could not pass a effective decree in absence of it. considering the submission made by the council. The further considering the submission made by the council for the council, Mr. Pulinka, the further proceeding in Manisut number so and so and state till further order issue notice to the so and so. You need the record also.
The records.
Record, okay, then first
In
issue
this
notice. At least issue notice to so and so. To register date and process. Date matter be according to this.
Further
You do
proceedings.
want any,
Yes.
yes, state, which is date. Do you want any fixed date?
Fixed it. Let it
For
be
your
after 4
convenience,
weeks.
I'm asking.
Let it be after 4 weeks because minimum 4 weeks was.
It will be listed after 4 weeks and the date to be fixed by 4 weeks. Take steps to take steps.
Further proceedings of title
Yes.
suit number 30.
Title suit, no, it is money suit.
Sorry, money
Yes,
suit number
is on
37.
state. No, I already. found.
Yeah.
This is bail method. Bail.
Bail matter, yes, yes.
But an FIR laws with false allegation against the father by the daughter that she had been raped. This has been made clear in the court when she was examined. Kindly see, madam. Even in the medical report, there is no evidence to show that rape has been.
Have 4 minor children, Lordship. Only on that ground, Lordship, I have approached this honorable court that howsoever rape may be the allegation, Lordship, but considering the health conditions of the wife of the accused person, he may be released on bail, Lordship. And I have enclosed the medical documents, which is at Annexure 5, Lordship. Page 23. This is a prescription of BK Memorial Hospital. Now, I have also taken the records of CHC Kalaktang, Lordship, which is a government hospital. So this record may also be considered. So only on that ground, Lordship. Till since there is no one to look after the wife. So if he is not released on bail, then as per the doctor, she need immediate operation, Lordship.
May it please your lordship. Your lordship, otherwise your lordship, apart from this medical report, your lordship, there are sufficient incriminating material wherein your lordship this fulfill section 37 of the NDPS is mandatory for granting of bail under section under the offense where the commercial quantity involved, your lordship. So otherwise, your lordship, presently they are not approaching this court on the basis of merit, your lordship, simply on the basis of humanitarian consideration. So, your lordship, so far as humanitarian consideration is concerned, your lordship, I would like to fairly submit that, your lordship, it has been held by the Honorable High Court of the Karnataka, your lordship, in case where, your lordship, the whole of the merit of the case, the court give a consideration, give a humanitarian consideration. In that case, your lordship, the rigor of section 37 will not operate. And considering that aspect, your lordship, the learned court has granted interim bail, your lordship, for treatment of the accused itself, your lordship. So, your lordship, only on that aspect. Yeah, otherwise, your lordship, whether what kind of disease she is suffering from, whether it is severe or not, that is not within my purview to make submission, your lordship. But however, your lordship, whether it is permissible or not, that I will apprise this court, your lordship. On humanitarian consideration, because your lordship, the offense involved commercial quantity, your lordship. So section 37 has to be come across. But in this judgment, your lordship, ILR 2003 Karnataka 474, para 9 from para 9, 10, and 12, Your Lordship. May I read para 9, Your Lordship? May I read, Your Lordship? The provision of Section 37 of NDPS Act make a drastic departure from the conventional canons of burden of proof of prima facie case against the accused on the prosecution, even at the stage of bail. In respect of the offences under the NDPS Act, the onus is on the accused to prove the innocence, non-complicity in order to secure bail. The restriction of Section 37 relates to prima facie material regarding the guilt of the accused. The power of the High Court to grant bail under Section 439 are quite wide and discretionary. Notwithstanding a prima facie case of guilt under the exceptional circumstances, the High Court in its discretion can grant bail. The embargo placed under Section 37 of the NDPS Act operates only when the court is considering the bail application on merit. Thus, the provision of Section 37 does not claim or keep the power of the High Court to grant bail under Section 439 in its entirety. In other words, Section 37 operates only as partial eclipse on the power of the High Court while deciding the application on merit with reference to prima facie material of guilt. Then only the provision of Section 37 operates, and they have to be read into provision of Section 39 CRPC. When the bail is to be granted on other extenuating circumstances or humanitarian ground, like the medical ground, the power of the High Court under 439 are not curtailed. The provision of Section 37 does not act as a blanket ban on the power of the High Court under Section 439 CRPC. On careful reading of the decision of Supreme Court in Kishan Lal case, I find that there is a no ratio laid down to the effect declaring the 37 of the NDPS Act operates as a total blanket ban on the power of the High Court under Section 439 of CRPC. In the present case, the accused is seeking bail on medical ground, and the court is considering the case of the petitioner the whole prima facie material of guilt placed by the prosecution. On humanitarian consideration, the power of the High Court under Section 439 of CRPC to grant bail is not eroded or affected by the provision of Section 37 of the NDPS Act. Now, Your Lordship, come to para 12. In the present case, the medical report are produced. The petitioner is suffering from serious heart ailment, and there is 90% blockage of his arteries. Immediately bypass surgery is advised. Even after bypass surgery, the post-operative care and treatment is necessary. A patient undergoing bypass surgery cannot have brisk and risky movements. In that view, I find that the petitioner at the time of operation and after operation for substantial time has remained docile. It may not be probable that the petitioner would make any drastic physical effort to abscond, hazarding his life. Accordingly, I pass the order, Your Lordship. Here, Your Lordship, in para, Your Lordship, 13, Your Lordship, per second, third for sub para, the petitioner is directed not to tamper with the prosecution witness. After limited period of 3 months, the accused shall surrender before the trial court. Here, Your Lordship, limited interim order has been granted. Now, Your Lordship, I will leave it to Your Lordship discretion whether that medical ground he has taken, he is not suffering, his wife is suffering. Whether that can be a ground for granting bail on the humanitarian consideration, or that I will leave it to Your Lordship. Otherwise, Your permissible it's.
Lordship, on various occasions, even for school-going children also, the accused has been released, and there are catenas of judgments, Lordship. Now, with regards to the health of the wife, Lordship, had there been some other family members who could take care of the wife, that would be a different case, Lordship. That is why I was not pressing on the merit of the case, Lordship.
Case has already been charged with this one.
Lordship,
Case, Your Lordship, perhaps it's not been charged sheeted, Your Lordship. Yet, Your Lordship.
All the-
Status report we have received, it's a very old status report. Since, Your Lordship, he's pressing on medical ground, Your Lordship. Updated case diary was not called for. Your Lordship.
now, Lordship, all statements, everything has been recorded. And moreover, I do not have any criminal antecedent also. Now, whether I'm innocent or guilty, that is a subject matter of trial before the court. But till then, since I have been, my name has come up during the course of investigation, but my family should not be suffered, let suffered, Lordship. Now, I humbly pray that, considering the period of detention and considering that the health of my wife, Lordship, I may be released on bail. If not on regular bail, at least for treatment of my wife, Lordship.
in Pataki, heard Mr. Vipaku, the learned counsel for the petition, also heard Mr. T.A.T., the learned additional people, appearing on behalf of state respondent. It's an application, section so and so, so and so, in connection with so. City receipt, petition, conference. It is submitted by the land council for the petitioner that initially the FIR was lodged against the driver of the vehicle, therefore the alleged recovery of cannabis, wherefrom there was, wherefrom there was, wherefrom the alleged recovery was made. The alleged recovery of cannabis was made by the police. However, during the investigation, the present accused petitioner was arrested in connection with this case. Section 37. But the petition was also filed by the petition. Medical assistance and according to medical operation and as there is none to look after his wife and children, he therefore feel so what is that the accused to the pay in the federal operations. There is sufficient evidence against the present petition and commit such offense in future. Thus, however, to submit the petitioner or the ground is in case of petition that his wife is needed for instance, also the ground or may consider the goal in the waiver of section 37 to not support. In support of this submission, so the recommend decision of Honorable Kerala High Court reported in ILR 2003 8AR 474 wherein court granted bail to the accused considering the immediate medical considering his medical ground. In that case, the court observed that the 37 report 37 and the case have cannot fall while considering the bail petition. stated that the patient, the wife of the deceased is suffering from rheumatic heart disease, and she was advised for bed rest. She was advised for complete rest. But there is no such advice of an operation to the patient, wife of this also. And in the same time, the decision which is cited for the non-operation, we see that it was a very acute condition of the heart disease of the accused, who was wherein 90% of the heart block is there, and immediate operation was advised by bypass and immediate bypass surgery was advised. And considering that aspect only, the Honorable Kerala High Court granted the bail to the accused petitioner for an immediate review. They could withhold the bail. But here in this case, the simple ground, medical grounds for wife of the so wife of the accused petitioner do not find any immediate ground in any immediate medical urgency for the accused petitioner, medical urgency to grant the accused petitioner to allow the accused petitioner to go on bail, only considering the medical and the medical ground of the wife as well as and medical ground of the wife. Considering the entire injury of the other, we cannot find the bail with case to allow the accused to go on bail. Lordship, that means it is rejected.
3 months.
No, it is rejected. I have it.
Obliged, Lordship. Your CD was called for, and we have received the case diary, Your Lordship. Case diary received, Your Lordship. Here in this case, the present accused has been granted anticipatory bail. However, Your Lordship, there are serious allegation and the material so far as collected clearly established the prima facie case against the present accused, Your Lordship.
Otherwise, case was under section 53457
And read with arm's sake also, Your Lordship. He was not possessing the license, Your Lordship. He was using the arm of someone else, Your Lordship, as per the case diary. And empty, Your Lordship, cartridge has been received from the place of occurrence, and the fired projectile also, Your Lordship, collected by the investigation authority. And on the last occasion, he has been directed to appear before the IO within 4 days, but he has not appeared within the 4 days. But after expiry of 3 days only, he appeared, and from his possession only the firearm has been seized, Your Lordship.
Lordship, in this case, the alleged person has appeared before the IO twice after this honorable court has granted the interim protection. And now the 161 statement has been recorded, and every procedure that has to be done by the IO has completed. Lordship, and I have cooperated with the IO, as and when called by the IO. And as of today, I have summoned 3 times by the IO, and I have presented before the IO. Now, by order dated 8/1/2024, this honorable court has issued notice to the respondent number 2 also. So I have, yes. And the steps were taken, but
Your Lordship, in this case, notice to the respondent is not required. This is not a POCSO case, Your Lordship. It's moreover, it's anticipatory bail, not application under 439, Your Lordship.
however, this honorable court has issued the notice. And moreover, Lordship, the matter has been settled outside the court by the parties. And to that effect, if this honorable court has permit, I may allow to file an additional affidavit by showing that the matter had been.
You want to file an
Yes.
Yes, Your Lordship, this, the aspect which is to be considered in the bail application is not their settlement deed, Your Lordship.
No, not at all.
Yes, Your Lordship. The issue here is, Your Lordship, may kindly peruse the case diary, Your Lordship, Your Lordship. The involvement, he has fired 5 or 4, Your Lordship, this bullet near the premises of the victim, Your Lordship. And he is not possessing the license also, Your Lordship, firearm license. Your Lordship, I have Your Lordship mark the page in this page mark is there, Your Lordship. The statement of the accused, Your Lordship.
How the injury caused? Is there any medical report also?
Medical
No
report is
injury,
there.
no,
No, no medical report is there, Your Lordship.
But there was an attempt.
Yes, Your Lordship, attempt, Your Lordship. And Your Lordship, the material has also been collected, the empty cartridge, anti-bullet cell, Your Lordship, from the place of occurrence.
Lordship, the dispute arising between the two brothers.
Who?
Yes, two brothers. The alleged accused person and the complainant are brother.
And Your Lordship, till date, Your Lordship, as by the case diary, no license has been submitted before the IO till date. Whether we don't know whether there is a license for this firearm or not, Your Lordship. According to the statement of the accused, the firearm belongs to his uncle. And uncle, he didn't appear till date. However, it clearly means that he is not possessing any license for that firearm, Your Lordship. That is clearly contravened to the Section 3 of the Arms Act, and Section 27 is attracted. And it falls under serious offences, even for the settlement, Your Lordship. As Your Lordship aware of the Lakshmi Narayan case, it falls under heinous offence, Your Lordship. And-
All those
and the
question
sta-
aspect would be clear by the IO during the investigation. And if IO require more investigation, then I'm ready to cooperate.
And Your Lordship, as per the 161 statement, he has admitted his guilt also. Is there, Your Lordship. He has committed. In their petition, Your Lordship, they decline everything. They are saying that they have not committed anything. But as per the 161 statement, the person has admitted his guilt, Your Lordship. He has committed the offense at that point of time, Your Lordship. For this purpose of anticipatory bail, it's a privileged bail, Your Lordship. Whether the person has been falsely implicated or not, or whether the prima facie case is made out or not, that has to be looked into. So here the clear-cut prima facie case is there, and that offense to serious, Your Lordship, 307 firearm, this Arms Act, Your Lordship.
Any other submission from you?
Yes, Lordship, since I am cooperating with the investigation, however, the accusation is grave serious. But although the accusation is serious, but I am cooperating with the investigation. If IO requires further investigation, then I am ready to cooperate with the investigation. So till then, my protection may be continued. I may be protected for that.
Yes, it's the possessing and prohibited arms without license, even itself is an offense. And that too, most probably at the time of incident, he used the arm also because there are some 5 numbers of cartridges were also recovered. So if a person is released, again, there is a chances of committing some kind of offense because you are using a arm without having any license in your name.
No, Lordship, for that, this honorable court can impose strict terms and conditions.
There will always be an apprehension for the other side also, Your Lordship, because
Or otherwise,
He has already
investigation
been-
may be completed.
he was already been granted interim bail. And now my brother is submitting that they've entered into an agreement. Your Lordship, that itself create some kind of some kind of confusion, Your Lordship. It is very, the investigation at the very early, the initial stage, Your Lordship. And Your Lordship may kindly see the last order, Your Lordship, wherein this learned court has not give any observation on the merit of the case. Simply notice has been issued, and imposing some condition, your interim bail has been granted. But all this aspect has not been considered, whether his involvement and all, Your Lordship. It's in the order was passed in 8/1/2024, Your Lordship. Now, Your Lordship, CD is before this honorable court, and CD clearly disclosed the prima facie case, and it clearly attract till that it can be presumed that Section 27 is attracted, because Your Lordship, that person itself has said that the firearm must not belong to him. He have taken it from some other person from the car without that person consent, and that person too has not produced the license till that, Your Lordship. It will always create an apprehension to the society, Your Lordship, in this kind of cases. If it was not a firearm, then my submission would have been different, but it's a firearm, Your Lordship, involved, Your Lordship, against which there is no license.
Lordship, even if I have possessed the illegal arms without any license, but what would be the meaning and purpose for arrest me? Since I am cooperating with the arrest investigation after getting this protection from this honorable court.
So I may be protected till the investigation is over.
Heard Mr. S. Now. Heard Mr. S. Now, learned counsel for the petition, also heard Mr. T.
You're not ESMA, Your Lordship,
Sorry.
or RINGO.
Huh?
RINGO.
Oh, I, sorry. Heard Mr. R. The learned counsel for the petition, and also heard Mr. T. The learned petitioner, appearing on behalf of said respondent. This is an application under section so and so in connection with so and so. CD receipt, page decision. Next way, is submitted by the learned counsel for the petitioner that after obtaining the interim PRS bill, he appeared before the IO in 3 occasions and cooperated in the investigation of this case. He is still ready and willing to cooperate in the further investigation of this case if he is granted with the privilege of PRS bill. Further, he submitted that the matter has also been settled outside the court, and the the informant has no objection.
Empty cartridges were, Your Lordship, seized from the place of occurrence, and one, Your Lordship, this fired bullet, Your Lordship, projectile, the front part, the main bullet. It was also recovered from the place of occurrence.
5 numbers of empty cartridges and 1 fired bullet is also recovered from the person place of occurrence. Further, he submitted that as per the accused, the license, there is no license in his name. However, this is the firearm which has been used by him was is under the license of his uncle and uncle Gustav. During the investigation till date, the uncle of the accused also not appeared before the IO, nor the license is produced before the IO, and thus it is not at all. It cannot be believed that the licensed firearm which was used by the accused petitioner is actually a licensed arm or not. So considering the report of the IO as well as the records in the case diary, further custody interrogation may be necessary for the just and proper investigation of this case. Accordingly, the United Additional BP raised objection in allowing the accused petitioner to grant the petitioner to dismiss the petition. Next, after hearing the submission made by the learned counsel for the petitioners, I have also perused the case diary and the statement made by the accused as well as progress of the investigation from note of the IO. It reflects that the accused admitted his guilt before the IO, and it is the case wherein the one firearm was used by the accused without having license, and in the same time, it is also seen that the license which is in the same time it is seen that the person, the uncle of the accused who is stated to be the license holder is not appear before the IO to cooperate in the investigation of this case. Accordingly, I find that there may be
Lordship, at least I may be protected from order, since I am cooperating with the investigation and I will cooperate with the investigation
I may not
till
tell-
the,
I may
to the
not tell-
satisfaction of IO.
Come up with another petition after some time, let the license be produced by his uncle. But at the same time, I do not. find
Lordship,
it difficult to
at least I may be protected, since I am
What
cooperating.
protected?
Yes,
That
I may be
protected in
protected
absence
from,
will be made
yes.
absolute only.
Yes,
Other
yes.
kind of protection.
And
will
this,
be
yeah, otherwise this interim may be,
Interim
made
is,
absolute.
interim stands vacated.
Your Lordship, CD may be
I
returned.
am not saying, I am not passing any order that I.
Yes,
will
it
get
is the
liberty.
IO is in liberty, Your Lordship. It's upon the IO whether his custody interrogation required. It's on the IO.
The party, if you are already cooperated with the IO, may not be the occasion or position to
Yes.
arrest you also. Or after some time, after some days later, if you file any objection, and in that case, if the license and the uncle is also appeared before the IO, then maybe there may be an investigation.
Since I have already executed a 25,000 of bail bond before the IO.
Huh?
25,000 bail bond before the.
Yes,
IO.
And
That
that-
count we have to
So,
make.
in this,
That is the procedure part, Your Lordship. That will be, they will get it back when he is acquitted. Your Lordship, CD may be returned, Your Lordship. This
Yes,
origi-
CD may be.
Okay. Deeply obliged. Your Lordship.
the payment.
There are three items. Item number. No, 7 of the one. Mr. Kopi was supposed to. No, you come. You're item number 7. Oh, because I'm missing it. Item number, yeah. This one. हाँ नहीं 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 वो नहीं बोला ये 20, 20 and 21 टाइम दिया था ना तक नहीं काम इसके बाद तुम ये बेल ये को खत्म करना 7 have you received the
CD, yes.
yes
Yes, Your Lordship, may I please?
yes
Your Lordship, on 9th of this month, this is,
9th of this month
yes, this is anticipatory bail application 5 of 24, Lordship, under section 468 of this month of 9, Lordship. Interim was granted.
you are on interim
Yes, I'm on interim. On 9th of this month, I'm on interim, Lordship. And on 10th, and have compliance the all the necessary consideration.
before the IO.
On 10th of this month only, on the prior to the next day. And also I have executed a bail and bond of rupees 25,000. Not going to the merits of the case, Your Lordship. This is all the necessary requirement. I have compliance with this Honorable High Court, Lordship. At this stage, my bail will be regularized, my Lordship. And this is the case of 468, Lordship. I have compliance with all of, I have made 161 statements.
And there may be some supplementary evidence.
Yes, Your Lordship. Your Lordship, in fact, I would like to bring Your Lordship to page number 10. Let's start with the FIR, Your Lordship. Lordship, the typed copy is at page number 11, Your Lordship.
Yes.
Now, if I may read, Your Lordship. I would like to inform you that 9 numbers of sanction orders amounting to rupees 85 lakhs were prepared fraudulently under the signature of the undersigned by some unknown person. The sanctions so prepared were submitted to the Chief Engineer Western Zone for further process and passing the bills. Copy of 9 sanction order along with fund allocation copy from Planning Department under United Fund for the year 2023-24 is enclosed herewith for registering a case and necessary inquiry. Now, this is what the case is, Your Lordship. He has forged the signature of the Deputy Commissioner, UPA, and has issued the sanction. That was what was the case about. Now, Your Lordship will see, I have also submitted the CD, Your Lordship. All the sanction copies are there, Your Lordship. Also, the statement of some of the witnesses has been taken, Your Lordship. Now, though on 9th of January 2024, interim was granted, if Your Lordship will come to the order of 9/1/2024, Your Lordship. Your Lordship will see the condition, 4th condition, Your Lordship. That has clearly been violated, Your Lordship. For the objection of the IO in this case is that first, he is not cooperating. He has, I have also flag marked his statement, Your Lordship. He has not clearly he has not clearly stated as to how the sanction was issued. Because your lordship is well aware, if a sanction is issued, it has to be processed from DCOPs to the financial, it has reached to the financial bill, your lordship. That's where the those fraudulent act was caught and FIR was filed, your lordship. He has not revealed the name who was associated with him, your lordship. Nothing has been revealed. Just because he has got an interim, he just gave a small gist of the story that so and so happened, your lordship. I have clearly flag marked the statement, your lordship.
This much only is stated.
Yes, yes.
I took something after something. There was description how we issued those sanction orders.
Nothing, your lordship. And therefore, your lordship, with the conditions that he should not leave the jurisdiction without the consent of the magistrate, your lordship. In fact, the IO has been calling him, your lordship. He has not appeared thereafter, after the interim was granted, and he has given this statement, your lordship. Subsequently, another call was made and he said that he was out of station, your lordship. Such kind of excuses are being made, your lordship. He has not been cooperating with the interrogation, nor complying with the condition given in condition in interim bail, condition 4 of the interim bail, your lordship. There is a clear request from the IO that since this must be a modus operandi, your lordship. This is not only a one time, and his statement is not satisfactory to the IO, your lordship. His custodial integration is therefore necessary, your lordship, in that case. Because a sanction, if your lordship will see a sanction order without the help of an office bearer, cannot just be passed, your lordship. It has come to the end of a financial secretary when this fraudulency was caught, your lordship. He is not revealing anyone's name, your lordship.
Yes, regarding the condition made by this honorable court, there are 4 conditions made. One was where the accused has investigation. Apart from investigation, this person has appeared on 10th prior to the interim application, which was passed by the honorable on 9th. On 10th, I have went to the police station. I have made 161. Also, I have executed the bail amount, which amount of 25,000. I have the records, CGM.
You have executed bail.
And regarding, I belong from this area itself, Lordship. Whenever there is no chance of inducement regarding all that. I will appear before this honorable, before the police station whenever they are required, Lordship. So there is no jumping to all this condition, Lordship. So my prayer will be this bail application may be regularized at this stage, Lordship, because I'm here on the matter of 468, Lordship.
468, right? Is that for you? Okay. Can you be given another chance to appear before the IO before the conference? Otherwise, so he is not cooperating.
Yes, yes. The second condition itself is if and whenever the IO is required, he has to appear. It's not just a one-time appearance. Your lordship is well aware. Yes, they have been calling him. He's not appearing. The other days he is out of station without prior permission from the chief judicial magistrate. Otherwise, your lordship can fix this matter some another day with an updated CD, your lordship.
So from his statement also, it seems that it's not at all satisfactory.
Not at all, your lordship.
Disclosing anything.
Yes, yes. And the first page of the status report, your lordship, point by point, the IO has clearly objected the bail, your lordship.
So we can do one thing, we can call for the applicant case there. In the meantime, he may be asked to appear before this way. So
Yes.
that can be done.
Comply with the
And
interim
comply.
order. Yes.
Otherwise, Mr. T. Taba.
Bitava.
Huh?
Bitava.
B.
Yes.
Mr. B. Taba, the Learned Counsel for the petition. So Mr. T. Zuni, the MST Zuni, the Learned Edition P. APM on behalf of State Respondent. This is an application in section 20 in connection with 20. It is submitted by the Learned Counsel for the petitioner that immediately on the after obtaining the interim pre-arrest bail on 9/1/2024, he on the next day he appeared before the IO and cooperated him in the investigation of this case. His statement is also recorded by the IO in section 161 CRPC, and he is still ready and willing to cooperate the IO in further investigation of this case. In this context, Ms. MSTJ, Leilani Divisional PP, has submitted that from the note of the IO, it is very much clear that he is not cooperating the IO and he is not appearing in spite of several repeated calls from the IO. Not only, furthermore, he also violated the condition number 4. Condition 4, which was condition number 4 of the bail order dated 9/1/2024, and without taking any leave of the Chief Judicial Magistrate UPR, he was out of station when the IO called for IO was calling him in seeking his cooperation in the investigation of this case.
First of February, Your Lordship. Yes.
We're giving another chance. Yes, because considering the day on the very next day we appear, but disclose everything. If you are guilty, if you are not guilty, I don't know what to expect, but it is the allegation clear by allegation against you that you made sanction of some huge amount of money about it, tax in the name of Deputy Commission, and clearly submitted that without the help of any other officials, cannot do it.
I will make sure he appear.
Disclose everything. Therefore, the court is to investigate the matter. There may be some other person involved in the matter. It is the economical.
I do oblige.
Yes, my lord.
You are on interim?
Yes, we have.
Acha.
And accordingly, on the direction of this honorable court, we appear before the IO, my lord.
Huh.
And given the statement and bail bond, as per the direction of this honorable court, 35,000 has been executed, my lord.
So now what is your, I see this picture.
CD receipts, yes. That
He appeared.
gun,
No, he appeared before the IO.
yes,
That is there, and the other part
and the weapon recovered on production of the accused.
on production by the,
Yes, on production of the accused, and it was licensed gun.
it was a license gun.
Gun. But shooting incident is disputed because I could not found any pellets
of the,
The thing is still disputed,
yes, but not yet certain.
not yet ascertained why.
Means there is a, this is a case of complaint and counter complaint. Earlier, this applicant lodged a complaint that he was assaulted by 6 or 7 persons, having lethal weapons like dao, and he luckily escaped unhurt. Thereafter, this other party lodged a complaint against this present applicant that he entered into his house. That means criminal trespass, having revolver, pistol, and 2 gun fire shot was done. That is alleged. No injury report of any victim.
And the use of that gun is also disputed.
No, it was recovered.
Cartridges were recovered or
No, cartridge not recovered.
not recovered?
Yes, but gun was recovered on the production of the
So
accused.
that's production of the accused. I'm
Yes.
saying that whether it was used also.
It was.
Gun was used,
It was not yet ascertained.
not
It was.
asserted.
Yes, not yet ascertained.
Actually, my lord, our submission is on the day of incident. I haven't wear the gun, my lord. Though I have the gun license gun, my lord. During the time of incident, I haven't took along that my gun, my lord. And the fact of the case is, my lord, actually this informant, he was not in the house, my lord. The my lord may see the FIR lodged by the complainant informant, my lord. Actually, because this accused and his mother was actually having a illicit affair the previous occasion, my lord, and that has been settled by the KEBA. And-
Accused and whom?
Accused and the informant's mother,
Acha.
they had illicit affair, but the matter has been settled by the KEBA, and then the same incident has been again mentioned in their FIR, my lord. The prima facie is very doubtful. By seeing them, actually, alleged accused person visited their house, informant house, all because to take the keys of their stall while they were celebrating the Sridonji festival, local festival, my lord. They have opened in a group. They have opened a 2 stall, my lord. And it was around 10 a.m., my lord. And the stall was still, stalls were still closed, my lord. So after inquiry, it's come to know that he is with the informant's mother. And accordingly, as per the information he received, the alleged accused person visited his home, their home, to collect the key on. By seeing them, they have
But
they
earlier,
closed the
as
complaint.
he submitted that earlier you lost an FIR. earlier.
Yes, my lord. I have lost the FIR. They have chased me out, chased to my house residence, my lord. They have assaulted me, and after giving my FIR, they have lost me, lost another FIR. Their intention is, my lord, only to stop me to meet her mother, my lord, their mother, my lord. That is their only intention. Actually, my intention is not to meet her mother, their mother, my lord.
Meet. Why are you keeping an illicit relationship
Yes,
with his mother?
the matter has been already resolved, my lord.
Don't meet. You marry another girl and stay with her.
So
No
that is,
necessity of meeting an elderly lady. You are Mr.
Tidon, my lord. Payadon.
Your name is not here. T.
Payadon, my lord.
Record the name. It's not here. Heard Mr. So and so, the Lanet Council for the petition. Also heard Mr. G. Dalo, the Lanet petition BP, appearing on behalf of state respondent. This is an application in section so and so in connection with so and so city receipt. It is submitted by the Lanet Council for the petition that after obtaining the interim period, order of interim period bail on 11/1/2024, he accordingly appeared before the IO and cooperated him in the investigation of this case. He also produced the arm license, the key license arm before the IO, as was directed before the IO. Further, he submitted that the false and concocted allegation is brought against him only to harass him, as he earlier he lodged an FIR against lodged against him has had some associate relationship with the other informant, which was already settled before the ban. On the day of incident, seen with stalls and when informant used to and that a part of the incident that a part of the incident took place. However, he is still ready to report the case granted with privilege of interest. Mr. Dita submitted that after obtaining the previous pay, he appeared before the court. And from CD step, it is a counter case as the petitioner constant FIR alleging assault on him by 6-7 persons, and thereafter present FIR has been lodged against the accused by him. However, this seen from the already accused petition had produced access arm from the island. It also cooperated hearing fail order dated 11/1/2024. He is hereby made absolute with same terms and conditions.
Much obliged.
With this same observation, this stamp is
CD may be written.
CD may be written. CD may be written.
Obliged.
Mr. Topin, you had some, most probably you have some matters, huh?
Yes.
At that time, it was, then your she took time, but it's already one, I think.
Close.
Two matters are there, I think, 20 and 21.
Which I was on my leg in court.
Yes, I know. So most probably it will be taken by at two.
It was, yeah, sure.
At two?
At two.
Oh, you are also there?
Yes, in one matter,
In one matter,
21,
21,
at 2 o'clock.
at 2 o'clock.
No issue.
Respondent number 2, about the total outstanding payable dues by the respondent authorities to the petitioner and also to issue certificate of the payable amount. Accordingly, by letter number so and so dated 2/5/2023, the respondent number 2 furnished the details in the form of certificate of the outstanding payment due against each farms of the petitioner as follows. Now, these farms are mentioned in annexure 13 at page 1, which you will also have seen. Now, to this, they have filed a reply. Counter they have filed. First, will kindly take up the counter, and in the counter, also will find at page 8.
Page?
Page 8 of the counter. Counter is whether it is tagged along with that. This affidavit of position was filed.
Page 8.
Page 8, paragraph 13. Notice got paragraph 13. They have dealt with this paragraph 17, which I have read from the writ petition. And their reply is like this, that with regard to averment made in paragraph 17 of the writ petition, the humble deponent would like, madam, this will be paragraph 13 at page 8 of the counter, madam. Affidavit of opposition they have filed. Para 13 at page 8.
Yes.
Page 8, para 13, bottom paragraph. That with regard to the averment made in paragraph 17 of the petition, The humble deponent would like to state that the issuance of RTI reply in form of certificate by number so and so, dated 2/5/23 with the tabulation of total admitted pending bills of HTS bills is a matter of record and furnished by PIO ADFCS legal. At the same time, earlier also the PIO has furnished certificates dated 21/12/2022, 20 and 29/12/2020 issued by the then Secretary Director FNCS by letter number so and so dated 17/4/2023. Now, these also they have annexed as annexure 5 and 6, which your lordship will find at page yes. Page 43 of this internal page 43 of this affidavit, they have annexed the same letter. And these are pursuant to the two certificates mentioned, my lord, in annexure 13, which also they have annexed. Your lordship will find at page 24, internal page 20. I have also annexed in the requisition, that is also there. Page 24, lordship is got. So these names of all the farms are given, total amount is given. And then this is the letter mentioned in 2/5/23, my lord, which I have shown. There are two letters mentioned. This is by the Director of Food and Civil Supplies. And then annexure 3 series, page 24, 25, 26, 27, these are all of 21/12/2020. The next, you'll also find Secretary to the Food and Civil Supply Department also, from page 30 onwards, issued a similar certificate. And these are, there are
Should buy
four-
this one, is it? Food and-
Food and Civil
Food and
Supplies,
Civil
yes. Now, what I am showing to your lordship is in paragraph 189 of the writ petition, there are reference of two other letters, page 189.
Yes.
Those are 21/12/2020 and 29/12/2020. These are the letters which I have annexed in the writ petition also, but just now I have shown from the affidavit of omission. In our writ petition also, lords will find the same letter, my lord. Page 109. part question Yeah, 189.
189.
189.
189 I have.
189, the letter which I have already read.
Yes.
There, in that letter, there are reference of two other documents. There is 21/12/2020 and 29/12/2020.
Yes.
With reference to those two documents, in fact, those two admitted bills and certificates, these last letter was issued on 2/5/2023. And those letters and certificates I have annexed from page 109 onwards. This is what I will show. From 109, Lordship will find this 21/12/29, and from page 104, 29/12/2020. These-
109 is dated.
109 is dated 21/12/2020, and 104 is dated 29/12/2020. One set of certificates issued by the Secretary Food and Civil Supplies, and the other set of certificates in respect of 5 farmsmen and different farms, different beans, from 109 onwards. So there are altogether 5 such certificates. One of dated 21/12, the other one is dated 29/12. Now, as I have shown from the affidavit in opposition, they are saying that it's a matter of record, that means they are not disputing it. And in fact, subsequently, my lord, because in paragraph in the affidavit in opposition, my lord, they say that these certificates were issued by some earlier secretary. Earlier secretary, present secretary doesn't make any difference. Then I applied under the RTI, my lord, and in our rejoinder to this affidavit of opposition, Lordship will find in the record it is there, madam. Lordship will find at page 12. That will be possibly after the affidavit in opposition, Lordship.
Page 12.
Page 12 of my rejoinder.
Your reason.
Rejoinder will be after the affidavit in opposition.
Page 12.
Page 12. This has been furnished by the department pursuant to my application, which the forwarding letter they have given at page 11, just the previous page, man. By this forwarding letter, they have furnished this document. These documents I have obtained because to show that the affidavit in opposition which they have filed and saying that the bills and certificates which I have annexed are all matter of record, and that even the parawise comment which they have filed is pursuant to a long process of initially putting up the file, then taking the approval from the assistant director. My lordship, at page 12, you will find on the left hand side there is a signature of additional director of food and civil supplies. Then ultimately it was approved by the head of the executive, the minister concerned. I am just reading from here what is the content. Reference above letter received from so-and-so senior government advocate may kindly be perused. In above referred letter, senior government advocate, while forwarding the petition number so-and-so, the present petition manner, requested the state respondents to furnish the parawise replies comments for filing counter affidavit against the above mentioned petition. In this regard, the draft parawise replies comments is attempted and placed in the file for perusal and obtain government approval, as well as vetting from law department. Now, next page, Lordship, kindly see. The draft parawise reply prepared by the department in WPC number so-and-so has been examined with reference to the averment made in the petition with supporting annexures. Earlier, the same matters parawise replies was vetted by the law department in WPC number so-and-so, discussed telephonically with senior government advocate who has confirmed that the above WPC has been withdrawn. Earlier, we filed a petition, there was some technical defects, so I withdrew and filed fresh petition. On examination, it is found that the petitioner is claiming the admitted liabilities of rupees so-and-so, which is evident from a certificate issued by the department up to this extent by letter number so-and-so dated 2/5/23, which I have shown at page 189, my lord. The department has released a sum of rupees so-and-so, 6.72 crore earlier and rupees 38 lakhs crore earlier only in 2 installments out of the admitted liability of total 141,59,21,976 to the petitioner. On earlier occasion, the law department's views was as under. The crux of the issue is seemingly that the petitioner is claiming the remaining amount of the admitted liabilities out of rupees so-and-so only minus part payments already made, because part payment has already been made. It is also seen that the petition copy at annexure 13 from page 188 to 189, a certificate issued by dated so-and-so 2/5/23 by the department admitted liabilities stands to rupees so-and-so only, which is required to be admitted and complied by the department and not to contradict the same unless there is a specific order to the effect. So they themselves are saying unless something is coming contrary to this, amount should be paid. And then it says the department is therefore advised to finalize the parawise replies, reasons, and supporting annexures and made the same to the Senate government. Based on this, my lord, the present affidavit in opposition was filed. So in the affidavit in opposition, my submission before lordship is that on 2/5/23, when the certificate was issued admitting the amount has to be paid. Now, they cannot avoid making the payment. And on the last occasion, if your lordship sees the order sheet, my lord, this honorable court directed that in similar matters earlier, some orders were passed. And I think the have a copy. My lord, we also have been furnished with a copy by the department, marked to us also. All relevant orders passed in such similar cases, PDS matters, contractors bills. There were some payment on the first page. You will find there is a forwarding by the director of food and civil supplies addressed to the senior government advocate to be furnished to the court, my lord. Well, these are the various orders passed by the government from time to time, releasing payment to various contractors, not to us, because in the read petition, we have also mentioned that 270 crore was issued to some other contractors of the department for executing similar nature of work. So we, on that ground, we said there is a discrimination because our amount was not cleared. Then when various orders were passed, and in fact, the most detailed order is at page 68. Passed by Honorable Justice A.M. Gujar Barua on 25/1/2017. Lordship will find it page 68 by Lordship's Court by A.M. Gujar Barua. Just a second paragraph I'm reading for the purpose of showing that whether this case is of similar nature. Petitioner was appointed as a carriage contractor by the state of Arunachal Pradesh for the period from 2003 to 2005 by executing a carriage contract for transportation of various food, grains and other PDS commodities from FCI Godown to the different public distribution centers in Lower Subansiri district. It is the assertion of the petitioner that they had transported various food grains and other PDS commodities from FCI Godown to different public distribution center in the district from 2003 to 2005. Accordingly, on completion of carriage contract, the petitioner submitted bills for an amount of rupees 35 crore 90 lakhs 55,482 for payment to the Deputy Commissioner as per the terms of the contract. It is stated that the bills were checked and verified by the respondent number 3 and 4, and the same has been forwarded to the FCI for its verification. Thereafter, upon the bills being checked, rechecked, re-verified by the FCI at the district level as well as regional level, the Deputy Commissioner as well as the FCI approved the bills of the petitioner after due verification. Thereafter, as the payment of the bills were not forthcoming, the petitioner filed a petition being WPC number so seeking for a direction that the payment of bills may be made. Now, when I'm speaking the entire huge order, and just for the purpose of showing that the first paragraph mentions about the work which I have also executed in a similar manner. Now, let me kindly turn to page 73 to see what is the operative part of the order. The last but one paragraph, upon considering the same, if the department does not have any appropriate reason for not making the payment, the required claims be paid to the petitioner preferably within a period of 4 months from passing of the order. If the department is of the view that there are certain financial constraints, the possibility to make the payment in 2 or 3 installments can also be explored. So that is my submission, my lord. In our case also, bills are admitted. Pairwise comment which they have filed there, they have admitted that yes, this is a matter of record, the certificate which has been issued to us. And lastly, my lord, one more order was there, which is a very simple type of order passed by Honorable Justice S.K. Medhi, which also is there. The department has furnished, my lord. That you will find at page 97. Page 97 starts, my lord. This is WPC 101 of 2022. Now from page 98 onwards, the order starts. Hart Street Tea Party Learned Council for the Petitioner Society, which has filed this petition praying for a direction for release of the balance contractual bill for the carriage of PDS items from the year 2010, 11, 12 in the district of West Siam. It is the case of the petitioner that the work is in question was completed in all aspects thereafter. A total bill of rupees 15 crore 24 lakhs 88,680 was raised. The petitioner has admitted that out of the total amount, an amount of 5 crores have been paid to the petitioner on April 2020, and the outstanding amount is rupees 10 lakhs 24,088,680. Council Sri so has also drawn attention of this court to the reply dated so to the RTA application made by the petitioner regarding the outstanding dues, in which the amount has been admitted. What should we kindly see? Learned Counsel for the petitioner accordingly submits that the present case is a fit case for grant of necessary directions for release of the amount in question. Learned Counsel Senior Government Advocate Arunachal Pradesh submits that upon the instructions received, the claim of the petitioner is not opposed in principle. However, by drawing the attention of this court to the affidavit in opposition filed on Spencer, State Council has submitted that due to lack of funds, the amount has not been paid, released to the petitioner. The State Council, however, submits that as and when funds would be available, the outstanding bills of the petitioner would be cleared. In view of the aforesaid facts and circumstances and the undisputed position of the facts as revealed from the aforesaid discussion, this court is of the opinion that the petitioner is entitled to direction for release of the outstanding amount. In view of the above, the instant writ petition is disposed of by directing the state response to take immediate steps for release of the outstanding balance of rupees 10.24 crore. The amount be released as expeditiously as possible and in any case within a outer limit of 6 months from the date of receipt of the certified copy of this order. Failure on the part of the state respondents to make the payment within the time frame would be entitle the petitioner to approach the appropriate forum for payment of further interest. So in this background, I'm paying for a direction that they may be given some time to release the amount. Because the amount is admitted, nothing to be disputed by them. They, in the affidavit of opposition also, they have not disputed the amount.
Yeah, Lordship, the amount is apparently Lordship, it has been admitted. If Lordship see the page 104 Lordship. This is the certificate issued by the Secretary Food and Civil Supply who represent the government Lordship. Here 104 to 108. 104 to 108.
Yes.
These are the Lordship 5 certificates issued by the Secretary in respect of the present pending bills. This is 96 crore something also. And from 109 to 10 Lordship 13. The director Food Civil Supply again issued the same certificate. The Secretary has given the certificate.
double
Di-
confirmation
yes,
is there.
Director has issued the, and Law Department has betted in favor of the Lordship petitioner. And in our affidavit, we have filed, we are not denying the Lordship. So under this circumstance, my only submission would be Lordship, in one go and Lordship, sufficient time would be required to make payment. Otherwise,
What is the balance amount now as a whole?
96 crore Lordship,
96
what they have paid Lordship.
Some outer limit may be fixed. Otherwise,
Outer-
they will again, I will have to come again before the Lordship. Some outer limit within certain period they should clear in 2-3 installments.
Lordship.
As per you says.
Lordship,
Do you have anything?
at least 6 months time. would be required, Lord.
Like 6 months is too long. Let it be 3 months. In installment. In 3 installments within 3 months.
If it is 96 crores, suppose,
Nice.
within 3 months, then they say, if it
Interest
is on
will-
installment basis also, then it will come around 30 crores or something
30,
like that.
33,
30
30 crores.
33
something
crores
will
or
come.
something.
Lordship, because installment would be more appropriate, Lordship, because otherwise it will.
Definitely, although, yeah, I'm also on the view that
Mm.
installment should be there, otherwise it's a huge amount.
Ah.
That is
So let it be within the 6 months, Lordship. And installment may be,
month,
Lordship may direct Lordship within 6 months. It may be divided.
installment.
3 installment.
Something should be made clear, otherwise they will wait for 6 months. Let them pay, pay within, it's not 6 months, let it be 4 months. And in 4 or 3 or 4 equal installments, that will be better. Something for both of us, otherwise they will wait for 6 months and they will not pay anything to me.
Again, you have to come back.
Again, I have to. Let there be some relief for them also. So let it be 4 months with 4 equal installments, that will be better.
Then may I propose
4
Lordship,
months, even he is suggesting that 4 months, and let it be in 4 installment also, but it should be clear within 4 months. Otherwise, 6 months, maybe,
Okay,
yes, he
no
suggested.
issue.
4 months, even I am allowing you to even 3-4 installments, also,
Lordship,
so that it can be clear.
Lordship.
Because
Kindly mention
and-
4 equal instruments, so that otherwise they will not pay. Let them get some relief to the petitioner also.
And liberty will be given to pay like in one installment also.
oh, you're going to pay in 1
No,
installment.
no, liberty may be given. Apart from this 4 installment also, if state wish to pay, then at a time also liberty may be
At
given.
a time also.
Yes, yes. That is
That's
additional
it.
liberty only. That's in the interest of the petitioner only.
I'll be happy, man.
They will not raise any objection. on that.
Yes, yes. Sir. Otherwise, Lordship, we have to go by the order of this one court only, Lordship. So just liberty because I don't know
Government
exactly
has,
the,
that much of money to pay in one installment. We don't have
Yeah,
anything.
yeah, yeah.
Rather they don't have.
because
anything.
exactly I am not aware like exact fund positions of the state government. So therefore the
Yes,
liberty
the 4
is,
months we are giving in
Yeah.
respect for instance, and however the state will be at liberty to pay even in one installment. That will be.
no,
our-
no, no, sir.
If you're going to pay in one installment, it's okay.
No, sir.
I'll pass the order.
My,
Yeah. Deeply obliged.
Order to be. Item number? Yes.
May I lordship? Lordship. And
Here in, here also you are on interim or no? You are not in interim.
not in.
Acha.
Lordship, an FIR was lodged against me. That is an annexure 1, page number 11 here. So, as per FIR, I would like to read out the FIR. Most respectfully, it is to inform you that I, Srimati so-and-so, wife of so-and-so, a permanent resident of Biasi Blaze under Nyobia Circle, so-and-so, on dated 5 August 2023 at around 12:30 noon. Once, that is a accused person, applicant, your lordship, visit my house on pretext of asking someone's phone number. As I was inside the house, he asked me to open the door. The applicant is our neighbor and living in the same locality for past many years. So not knowing about his ulterior motive, I opened the door on my house. Soon after enter my house, he grabbed me and covered my mouth with his hand and unable to scream, me to scream. I desperately tried to release myself from his clutch and uh, scream out loud, but I couldn't, and succumb to his masculinity. Therefore, he forcefully raped. 3 weeks, madam. After matter will be released after 2 weeks, madam.
Or Mr. L. Panu, the learned counsel for the appellant. As per the office note dated 11/1/2024. 11/1/2024, the service is still awaiting for response number 1, 2, and 3. However, the learned counsel, Mr. Parme, has submitted that the item has already been delivered, and he submitted some check consignment report of delivery of item to respondent number 1, 2, and 3. Any further, do you want to file any additional affidavit
Madam, I'll put this document, madam,
along with?
on record, madam. through epidemic,
the
madam.
learned counsel, Mr. Parme, has submitted that he will file an additional affidavit in regards to the service of notice. Let the matter be accordingly listed. After 2 weeks?
2 weeks, madam.
After 2
Obliged, madam.
Please, Lordship. Lordship, on last occasion,
I was directed to take a press steps upon the respondent number 2
Hmm.
by providing correct postal address to the
Ah.
registry.
Ah.
So today only I could have obtained the proper address of the respondent number 2. So I may be
So you are
allowed
going to take steps.
Yes. And his proper address may be mentioned in the today's order, Lordship.
Heard Mr. R. Lilly, Dilani Council for the petition, and also heard Ms. D. Jenny, Dilani Division PP, appealing on behalf of state respondent. Where is the note? Yes, given. Oh, or you can write the address, okay. And then Mr. Dilani Council for the petitioner for the submitted that as per order dated 21/11/2022. He was asked to take press steps on respondent number 2
Two.
in proper and correct address, postal address, with requisite postage stamp. Accordingly, he collected the correct and proper address, the address of the respondent number 2, and going to take steps within going to steps on respondent number 2 accordingly with postage stamps. The address he has already collected is as follows. The address of sales name and phone. Heard accordingly the learned council for the petition, we have asked to take steps within 3 days from date of today. In the correct and proper address of the respondent number 2. Let the matter be accordingly listed after 3 weeks. Give the address to him.
Yes, Your Honor, I'm here in item number 13 as a respondent. I filed my wakalat number today. I'll be appearing on.
For so by on your appearance, the service is already
Yes,
complete.
yes, sir.
You are for respondent number 2.
There's only one
Only one
respondent.
sole respondent.
Oh,
I'm for the petitioner.
Same problem is there. Huh? No, the name of the petitioner file is also not reflected in council. Your name will not be reflected in the cause list.
In Wakalat Nama, there is reflected name. Cause list, it's not.
Hard MS, your good name?
M. Yaram,
Yaram. Any other senior council is also there?
T. Sunil.
P. Soren,
Yes.
appearing on behalf of P. Soren. And it is submitted, P. Soren for the petition. And
V. Jamal, Your Honor.
B. Jamo also appeared on behalf of the sole respondent and the file his Wakaratnama. But it is seen that in the cause list, the name of the learned councils for the petitioners as well as respondents are not reflected. And accordingly, the registry is hereby directed to reflect the name of the engaged council for both petitioner as well as the respondent in the cause list. You are going to submit any?
Your Honor, will file and let the matter be fixed on 13th of February. Since the matter is pending before the learned JMFC.
Let the matter be listed? on
No, Your Lordship, I have some difficulties on that particular date.
Any
It
date,
may be
Your-
fixed after 2 weeks.
You don't want any fixed date?
Yes,
After
Your
2 weeks
Lordship.
will do.
Yes.
Let the matter be accordingly listed.
Your Honor,
And Your Lordship, the interim order may be continued till the reasonable date.
Since Your Honor, from the file noting, Your Honor, I have seen that on office note dated 2/11 of 2023, the Honorable Court has given till returnable date, Your Honor. Without any, I would say, Your Honor, there is any, without any reason, since the matter is pending
the 13th February.
13th
It may be not, it may be another date, not the 13th February. Yes.
Oh, so 13th February, you
Yes.
have some.
Yes, yes.
Okay, then you say
14, 15.
14, 15, 16, 15
Any
is
day,
holiday.
Any-
before that also, not 7, 8, 9, 10, any day, convenient of it. Since you're not what, why I'm pressing you not, since you're not from the file nothing I've seen you not, on the, there was a notice issued to us, but from file nothing it says that service has not been served to us. And they were asked to take justice service and they have not filed that also. You're not-
No, your
I'm not
lordship.
going to, I'm not
Sorry.
going to all that, that is a different, and since you're not, this is a NI case, they have the case is sister, you're not, that's what my praise that matter can be disposed of as early as possible. They are trying to take an advantage of the interim order. And I have no issue, any day, you're not, but
Is it?
No, your lordship, I went to the house of the resident of the respondent to serve the justice service, but they didn't
Anyway,
accept the.
if you have some personal difficulty on
On
13th of
13th.
February, you can, it can be listed on item 15, 16, 14, whatever, or even prior to that.
any day, but I'm up
Any
to
day.
on the 19, 20, any day, which we can do.
And this time it
Yes,
is
on,
at your,
14
at your
Yeah, yeah.
choice.
For 14 February.
14th?
Yes, your lordship.
No issue on that.
No issue.
Or
Let the matter
admission,
be accordingly listed on 14th.
and you're not endeavor maybe, but taken to dispose of the matter on the. On the
I don't know, what is the position of case that I don't know now, so endeavor should not be there, but you make your submission. If it is possible
It
on
may
the
be
part
so,
of the court
for
to
admission, Your
dispose
Honor.
of the, it was on, no, it was on order column.
Yeah,
I'll make it on admission column. now.
admission column, yes.
Let the matter be listed on 14th of February in admission column. On that day,
Yeah.
the courts are listed.
Bibliography.
Deeply obliged.
May I please, my lord? My lord, this is a criminal petitions jointly filed by the accused and the complainant as well as victim.
Hmm.
The section is 279 and then 323 IPC. 279 is non-compatible in nature, my lord.
So why it is fixed in order column actually?
Your lordship, on,
LCR was called for last occasion.
actually what has happened, your lordship, earlier we have made an objection because there is a fundamental error in the basic fundamental requirement for the settlement, your lordship, because they are approaching this court squarely on the settlement deed. And we have raised an objection that all the victim has not been entered into an agreement. Only complainant and the complainant's son and one of the co-victim, he has not entered into the agreement, your lord. His name is not there in the agreement. He has not put his signature in the agreement, although his name is there, your lordship. So for that, we have raised an objection. And for that, your lordship, even the interim order was not passed by this honorable court, your lordship.
Interim order.
There is no any interim order as such, your lordship.
My lord, the thing is that the name of the person, one Ringu
Ringu
Talo,
Talo.
one Ringu Talo is not a victim in the case as per police charge sheet.
Your
And
lordship
also in
may
the
find
FI
it in page number 16 is there in the charge sheet, your
But
lordship. My
in
brother may have
individual
overlooked it, your
settlement,
lordship.
his name is reflected. But in charge sheet and then as well as the FIR, is not a victim in the case.
Your lordship, open page 16, your lordship. It is there in the charge sheet. My brother has overlooked it, your lordship. Page 16.
Page-
Yes, your lordship. Column 3, your lordship. Ringu Talo, witness. He himself is victim, one of the victim. In second, Ringu Appa, he is one of the victim who entered into the agreement. This column number 3 victim has not been entered into an agreement. So far as the Lakshmi Narayan case is concerned, the party has to settle the matter entirely among themselves. I am not objecting on the sections, your lordship, whichever under they have booked. My only concern is whether for the quashing a matter, all the parties must be there, your lordship, because the only two or the it cannot be pick and choose. By doing pick and choose, it cannot be quashed, your lordship.
Name of the number 3, Ringo Talo was there.
My lord,
And he
Yes,
was a
yes, your
victim,
lordship.
shown as a victim.
The one of the victim, he was a pillion rider in the motorcycle, your lordship. They have been hit by the accused, your lordship. They both were the main victim, that is Ringu Appa, and this Ringu Talo, they were in the motorcycle, your lordship. They were hit by the accused, your lordship. And for the,
One thing we do. It
Yes.
would be better, I think, in the form of additional affidavit.
yes.
You also file in the.
Yes, my lord,
compromise
my
of-
learned friend, since they are
Affidavit.
making objection for not making of the necessary party, so I may allow to file additional affidavit to implicate him as a party in the case.
Yes.
So till then, lordship may grant interim stay. because the trial proceeding is going on before the learned court of CJM, and it speaks of the evidence, my lord.
Your
So
lord,
since matter has already settled between the parties, so lordship, if evidence will taken up that it will just futile exercise, my lord. And it will wastage the time of the precious time of the court, my lord. The matter speaks on 18 March before learned court of CJM UPM.
then prior to that, let them file the settlement deed, your lordship. There is no any difficulty because if they have settled the matter, then I don't think there is any issue in filing a settlement deed, your lordship, where all the parties enter into an agreement.
That's why, my lord, will file additional affidavit for implead of necessary
No,
party.
he is party in this case.
No, my
Yes, your
lord,
lordship.
in fact,
No, no,
if
no,
we,
no, this petition is jointly filed by.
yes, jointly filed by the
Yes.
accused, victim and the informant. The petition is filed by the informant, victim and the accused, my lord. Petitioner number 1 is the accused, 2 is the informant, who is the father of the victim, who is, petitioner number 3, my lord. But now my
That
learned
means-
friend, they
that
are
means
making,
the other one, who is
Other
also
one who is a
considered
felon
to be a
rider-
victim is not mentioned, he is not.
Not there
party.
impleaded, yes. He is not
he
a
is not
party
a
in this case.
victim in the case, my lord. That's why we have not made him a petitioner in the case.
Your
One
lordship, I will
Ringu Talo is not-
satisfy your lordship whether he is a victim or not, your lordship. May kindly come to the charge sheet, your lordship. Your lordship, in page number 16 itself, your lordship.
Prosecution stories, I of the cases.
During the course of the investigation, the second para, your lordship. During the course of the investigation, I have visited the place of occurrence and observed the place of occurrence. The road is narrow, went toward straight from the powerhouse Chandanagar Tinali. Also, the road in rough Kacha Rasta and rough sketch map drawn on the place of occurrence. Also, I have examined the complainant and the witness and recorded their statement under so and so, in which Ringu Appa stated that on Itna and Itna, at around hour, he along with Ringu Talo were going from the powerhouse on a motorcycle bullet. Seeing a car coming on the way, he stopped the motorcycle and went on the side of the road. The driver of the car, recklessly driving the car at the speed, stumbled into the motorcycle, due to which the mirror and the leg guard were damaged. He stopped the car. Then they told him that the motorcycle was damaged due to his race driving and asked the motorcycle repaired. He was under influence of alcohol and he started arguing with them with anger. Them, your lordship. Seeing the Sri Ringu Talo start capturing video from his mobile phone, he got angry and started beating Sri Ringu Appa with punch and hit him on the neck with the key of the car, due to which the Ringu Appa got injured on the neck and other body parts. Seeing this, the aunt came there and got rid from him, your lordship. The both were there, your lordship.
Were there, but he is not the victim, he was also a victim. Or-
Yes, your lordship. He is in the motorcycle and
But
he was
Is there any medical report?
medical report, your lordship. It will there, your lordship, because
Cases registered under 279 and
323, my lord. 323.
medical report may not be there.
Yes.
Oh, no, it is there.
there it will be there, your lordship. This LCR is there before your lordship. LCR was called for your lordship.
That's why, my lord, as per charge sheet, so one Ringu Talo is not the victim in the case. That's why we have not made him a party in the case. Otherwise, if his name is mentioned in the victim, so we could make him a party in the petition.
Now see if there is any objection from the other side and if the case remains for the.
So
other
that's
defense,
why,
then
lordship,
it will be
I
a
pray-
problematic.
Yes, that's why.
So,
And your lordship, it is a well settled position now at this stage. I will apprise this court. Even if the person name is prosecution, name is even the victim or the accused name is not there in the FIR also. At the later stage also, if court find that the person was the victim, or the court can during the trial also, your lordship, call the person concerned for during the trial, your lordship. So now, your lordship, if supposedly, if this court quash the matter, and if this court has not, person is not entered into the agreement, later he wanted to, wish to, your lordship, participate the matter, then it will cause prejudice to him, your lordship. Only on that aspect I am objecting. Otherwise, your lordship, regarding the settlement, your lordship, that will become on the later stage, because fundamental requirement, they have to be fulfilled, your lordship, at this stage, your lordship. And otherwise, your lordship, this matter was filed on, was first moved on 6/10/2023, your lordship. From then, your lordship, till that, they have not filed an additional affidavit, because this issue was raised in many occasions as and when this matter was come before this honorable court, your lordship.
the other person is not interested in any.
Yes, my lord, he is not interested to participate in the case. Maybe.
No, no, not participator. I'm questioning you whether he is not interested to make an agreement of compromise with the other side.
My lord,
Well, it's very simple,
yes.
you can find the, you can.
so that's why, my lord, I pray that I may allowed to file additional affidavit
Yes,
for
you
implead
can file it
as a
in the
party.
form of additional.
My
affidavit,
learned
you file
friends
the
make
also-
objections.
and just the compromise. for the
Yes.
instance.
So, my lord, my part of prayer is that till then the matter may be stayed, trial proceeding may be stayed.
Your lordship, next date is on, according to my brother, next date is on March. Today is January, your lordship. February, entire month is there, your lordship. If suppose that person doesn't enter into an agreement, it will cause prejudice to him only because for that I am raising an objection. If he comes and file, then I don't have any objection on interim also, your lordship.
Mr.
Yes, ma'am. And
Mr. Anjana, the learned counsel for the petition, also had Mr. Deviated, the learned additional PP appearing on behalf of six on this is an application in section so and so, connection with so and so. This is the LCA. LCA has also been received, but it is submitted for the learned additional PP that the one of the victim of this case is not made party in this case. And he also did not enter into any compromise agreement with the accused. And accordingly, he submitted that there the issue may raise later on, and if the petitioner, if the other victim wants to pursue the matter, in that case, the accused petitioner may be there will be prejudice may be caused to the accused petitioner. Considering this submission and full stop. In that context, Mr. Rama, the learned counsel for the petitioner, submitted that he will file a compromise agreement between the accused petitioner as well as with the another victim. Mr. What is the name of the other victim?
Your lordship,
Ringu
Ringu Talo,
Talo.
your lordship. Ringu Talo, your lordship.
Not Lukuleva, Ringu Talo. And we're going to find the additional affidavit in that regard. Allowed.
And-
Further, he submitted that the case is at stage of evidence, and it is a fact that the compromise has already been, and there's a compromise between the parties, and in that case, if the case is further proceeded, then the accused petitioner will be prejudiced, and accordingly, he prayed for stay of the further proceeding in case number so and so. Considering the submission made by the learned counsel for the petitioner, the further proceeding in case number so and so is stayed till next date of listing, till next date. Full stop. Further, the learned the petitioner is hereby asked to submit the additional affidavit along with the compromise agreement with the other victim. Let the matter be listed. We want better to give a fixed date. No?
Yes, your lordship. And one more issue, your lordship, I would like to point out, your lordship. As per the CIS, your lordship, as in many occasions, this court has apprised us, your lordship, that the correction cannot be made by hand. Your lordship, here the present this victim, he is not impleaded as one of the party in the application petition, your lordship. Only
So that in that case,
amendment has
if,
to be.
if no, well, that's why I'm thinking that the other victim, if he enters into a compromise agreement with the accused person, that may be submitted by him through an additional affidavit.
Yes,
May be
and your lordship, and second issue is, your lordship, may kindly come to agreement. Your lordship already passed the order. I just I just pointed out, your lordship.
Okay.
Your lordship may read this second para, your lordship. We both party have made a local settlement on above cases pending on dated itna. The first party Ringu Kama, complainant, and the victim Ringu Apa and Ringu Talo had accepted the prayer made by second party. Now my brother is saying he is not in victim. His name is reflected in the agreement. His signature is there, not there, and now he is saying he is not the victim.
maybe, my lord, this agreement, during the time of making this agreement, so they have madly, wrongly written his name as a victim. As, in fact, my lord, as per police record and charge
Rightly
sheet,
or wrongly, whatever, but
Yes,
his name
yes.
has been reflected in the
Yes,
your
ma'am.
compromise.
By him only, and now he is saying he is not the victim. This is very strange, your lordship.
So definitely he is maybe one of the victims. I think in that case also he was there in the motorcycle, with the national negligence, whatever.
Yes.
So that may be one of the reasons.
Yes.
OMCL or particularly is not there because case is registered under section
Yes.
79 and 322. I think. Okay, now it is on March.
Yes, my lord.
So you will just file the thing, additional affidavit. by 12th or 13th of February. 1 month prior to the other day fixed.
12, 13 month, 12, 12
12.
month, yes.
12. The scan copy LCR can be retained to that time.
Yes, your lordship, it's LCR scan copy only, your
No, no,
lordship.
scan copy will be here.
Yes, yes, it's no difficulty. Original is there.
It is scan copy and scan copy of it. 12.
Obliged.
Deeply obliged. Yes, I mean. This is my lord, joint application, my lord, for crossing
It's also joint.
my lord. The accused, my lord, is sisterly in-law of the complainant, my lord. What
Accused is the sister-in-law of the complainant.
complaint, my lord? What happened, my lord, prior to this accused, my lord, observed in job, my lord, he used to live with this complainant in the complainant rented house, my lord, with his elder sister and this brother-in-law, my lord. Now, on my lord, is my lord, on 16/9/2023, my lord, on 16/9/2023, my lord, this complainant, my lord, oh sorry, my lord, accused, my lord, was supposed to withdraw some his belonging, my lord, from the rented house, my lord. Accordingly, he informed also this complainant also, my lord. I need to withdraw some my belonging, my lord. Now, unluckily, my lord, at that point of time, my lord, my elder sister relation and my brother-in-law was not good, my lord. Now I informed by that, but then as both the person, my lord, was not there, my lord, I informed and broke the lock of the house, my lord, and I took out my belonging only, my lord. Now there, as relation was not good, my lord, he lost an FIR, my lord. But thereafter, as of now, my lord, both my lord, my either sister and brother-in-law, my living happily, my lord, and we have entered into settlement, my lord. FIR, my lord, will find it 18, my lord.
Age?
18, my lord. 18, my lord. 18A is my lord, type out copy, my lord. May I read, my lord? On date 16/9/2023, one such and such of Download Village, a police by profession called me in intimation tone with a phone number such and such that she had come to my house, they are going to break my house. Lock on ground that she has to take item belonging to Peping Mego, my lord. This is my elder sister, my lord. I have requested her not to do the act in my estate, and I shall be reached by evening. Moreover, I told that there was no item belonging to Pepe Mego. Despite my several requests, she took lock and took my household item, and she restored that she is in the police and poor man like would not any harm to her. As such, I request your authority concerned to book his culprit in appropriate section of law for indulging in trespass, housebreaking, intimidation power, intimating power of being in police. Further, I request you to inspect the crime scene, assess the stolen item which I have not been visited my house, knowing the housebreaking. This is the FIR, madam. My according my FIR registered on 554 IPC, madam. My humble submission, my lord, at this the case at the investigation stage, my lord. As my lord, this was not between them my sister-in-law and the brother, my lord. My humble submission, my lord, they enter into my lord next date, my lord, page 19, my lord. Enter into settlement, my lord. Page number 19, my lord, is a settlement deed, my lord. By between the party, my lord. This is not 19, my lord. This is agreement deed, my lord. My humble submission, my lord, it is a pit case, my lord, to be filed, my lord, by evoking 482 CRPC. That is limited submission. Yes, your lordship, the case is an investigation stage and I have received the case diary, your lordship. And as per the statement, your lordship, yes, they were relative, your lordship. The accused and this present accused and the, your lordship, victim, they are relative, and accused is the sister-in-law, your lordship. Sister-in-law of the victim, your lordship. So it's perhaps it's a misunderstanding between the family, your lordship, and so far as the section is concerned, your lordship, the punishment is up to 3 years. So therefore, your lordship, in my humble understanding, your lordship, this is a fifth case where your lordship, basing on the parameter laid down in the state of Madhya Pradesh and the Lakshmi Narayan case, this can be settled, your lordship. can be quashed, your lordship, sir.
Me telling he is the complainant. Accused is Tome Megu.
Your lordship, here, Tome Megu is the accused, sister-in-law of the, your lordship, Tamu Talu, your lordship.
She is the
The accused,
sister-in-law.
yes, your lordship. Accused sister is the wife of your lordship, accused, or victim, your lordship.
Accused sister. What do you say? Accused sister?
Accused is my younger sister of the
Accused-
wife of the complainant, madam.
Accused
sister
younger
in-
sister is the wife of victim, your lordship.
Oh, that's why his relation is his
Yes, yes.
sister-in-law also.
And according to her statement, your lordship, she was staying with them only, your lordship, in the rent
Yeah,
house.
in the house,
Yes,
rent
yes, your lordship. So it's a family, it can be considered as a family dispute, your lordship. Yes.
Hard Mr. L. Permit, Illicit Council. This is the item number,
15, your
madam.
lordship.
item number 15,
15, your lordship.
15.
Yes, your lordship.
Hard Mr. L. Permit, Illicit Council. Item number 15. For the petition, also hard Mr. Created in Illicit Edition PP, appearing on behalf of state respondent. This is an application under section so in connection with so. No, sorry. This is a joint application. A joint application filed by the accused and the complainant. Under section 482 CRPC for setting aside and quashing the criminal proceeding under Pasighat PS case number 100 2023. Section 1. Accused is petition number 1 is the sister-in-law of the petition number 2 as complainant. Both the complainant and the accused were residing in a same house as in the same rented premises. But on the day of incident, when she want to withdraw all her belongings from the rented premises from her rented premises, there was an altercation between both the parties. And who was there? Another person was there.
No person was there, madam.
At one of them, as
Between them only.
no,
No,
madam.
no. When she came to ask for the key,
Madam.
one person came, na?
No, man, no party. As my lord, my relation between my elder sister and this complainant, my lord, was not good, my lord. According he reside in some other their native place, my lord. The person is where we reside, my lord, is rented house at
But
Pasighat.
elder sister came.
No, sister also was not there, my lord. So a key was not available to lock of the key was not available to anybody, my lord. Accordingly, I informed him that I will block this key and lock and I will withdraw my belongings. Your lordship, here is the statement, your lordship. The statement of the accused, your lordship.
asked her to wait for some more time. When, as it was very urgent for her, if she again informed the accused. Then he asked her to lock to break the lock of the premises and to take the belongings. Accordingly, she broke the lock of the lifted house, but as she had she did not maintain a good relationship with her elder sister. Connivance of the elder sister also from case is caused against her. But at present, both the accused and the informant entered into a compromise deed of settlement, compromise with the settlement, and matter has been compromised between the parties. According to the informant, is not interested to proceed with the case. Present petition is filed jointly by both the petitioner as well as the informant for setting aside and portion of the criminal proceeding pursuant to sales. Further submitted counsel for the petition that posed there is petition number 1, even if the proceeding is allowed according to the court, the portion of the criminal proceeding initiated so as as the both the petitioner and the informant the family members and who were resided same affected premises and due to some family dispute between parties the incident had happened and also considering the nature of the issue and the compromise between the parties he submitted that it is a case where the criminal proceeding can be quashed passed in Lakshmi Narayan's case another
State of Madhya Pradesh versus Lakshmi Narayan
state of Madhya Pradesh
versus Lakshmi Narayan and others
reportedly
in 2019-5 SCC 19-5
1995
SCC 688.
and thus there is no objection in quashing the criminal proceeding which is initiated under Pasighar PS case number 100/2023 under section 454 Act. Considering the submission made by the Honorable Counsel for the petitions and also considering the fact that both the parties have entered into a settlement, I find it a fit case to exercise the power under section 482 CRPC for quashing and setting aside the criminal cases on so will be the last. Disposed of.
Obliged, deeply obliged, Your Lordship.
My lordship, it's a joint petition under 482. In the instant, this joint petition, there is only one victim and one alleged accused. There is only one victim and one alleged accused, and this is being filed as a joint petition under 482 to quash the proceeding. And that. So, in
Case
this
is registered under which section?
324.
320.
Yes, it's only 3 years punishable, and it's a fit case to be quashed. And in petition, all those mutual settlement deed and everything has been enclosed. And mutual settlement deed is in page number 18. So they are the family friend, and this alleged accused is residing in the residence of this victim only. Alleged accused is residing in the means house of this victim only.
Why under what heading?
as a family relatives. They are family relatives.
Family relative.
Yes, and the incident happened. This incident happened uh, uh, in the bar and restaurant only, not at resident. They were having yes. So, but the main incident was in between the manager and the alleged accused. There was argument. So the chart sheet is there in page number 21. Please, page number 22. Main part is in page number 24. My lordship, please, page number 24. So in page number 24, that's last para. During course of investigation, that's last para, it came to light that on 30th January, around this hour, the victim along with his friend Sri Jan Dole went to UPI to visit this person motorcycle. And at night, they returned back to New Delhi. And while reaching Bagatinil, they had planned to go to bar. Meantime, the Hancock bar staff were seen disposing the litter and were about to close the bar. The victim and his friend requested the bar staff to allow them to enter and spend 1 beer for each. The bar staff accepted their request and allowed both for some few times spent. While entering, the victim saw the alleged person was sitting inside the bar and they met and had spent together almost 2 hours at the bar. After the bar manager, Sri Krishna Gyadi, requested them to leave home as it was too late. Meantime, the alleged accused has caught sudden hiccup. And the victim and his friend, Jandole, insist the bar staff to serve some liquid drinks, but the manager denied their request that the bar counter is closed and they would not be able to serve anything. Then the alleged accused person got anger in the pretext and altercation with the bar manager, this. However, the bar staff managed to drive them out and immediately closed the grill gate of the bar. On anger, alleged accused person came back with the machete and swung the grill gate in order to scare the bar staff. Meantime, the victim had tried to cool his temper and tried to snatch away the dhow from his hand. Later, the alleged accused person attacked the complainant by swinging his machete and contact on head, backside of the body and caused injuries. Therefore, this charge sheet has been framed under 324. That charge sheet that is in page number 27. So charge sheet is in 27, para number, second paragraph. Heard both the learned counsel on the point of charge peruse. Upon hearing and perusal of the record, this court found that the inclusion of Section 324 IPC is attracted, and there is a strong presumption that accused person might have committed the offense under Section 324 IPC, as alleged. Simple injury. Injury, victim. That
Name of the victim?
victim name is Sake Pao. That's petitioner number 2 in this instant joint petition. So for the same means, this is the exact and even in page number 26, there is a 161 statement of this victim also.
Yes, Mr. Adam.
And I would like to praise 2 judgment from this one, from this Honorable High Court only, Guwahati High Court, Rido Pana and others, where same case has been twice, almost fact and circumstances is same for 324. And another one is that's principle being laid down in this Narendra Singh case that by Apex Court in 2014. So based on that, most of the cases has been quite, and in this case, this is on especially for 324 only, both cases. So if Lordship may allow, may I go through this? Okay. So that's only just
Para, we're emphasizing the para number.
Para number
Which para you are emphasizing?
for Ridopana, for Ridopana, this Narendra, the fact is there in page number.
Para, you are emphasizing on which para?
Okay, para is there in this paragraph number. Paragraph number 12. Yes, page number 9. And page number 12, and also page number 12. And also the paragraph 32, 33. Page number 20, page number 20. So, page number 20, paragraph 33 may be read. Page number 20, paragraph 33, double three. Because in this Narendra Singh, a catena of cases has been examined. So based on that, the criteria has been laid down.
Yes, as per charge sheet, LCR, CC was already done. Charge was already framed under, yes, 324. Now it's pending for evidence. And from the record, it seems that both victim and accused are friends. They went together to the bar and had beer together also. On being drunk, this accused argued with the bar manager to provide more. Then this victim interfered him. When out of anger, this accused hit the grill of the gate by his dao. So victim interfered. And then accused his anger shift to his this one victim, his friend, and inflicted injury. And as per MLC, it's simple in nature, but caused by sharp weapon. So there is a settlement agreement, and both are tenant and rent owner. It can be best.
Tanya Kipa. Tanya Kipa. That's in cost.
Appearing on behalf of state respondent. This is an application under section 482 CRPC for washing. No, this is a joint, sorry. This is a joint application under section 482 CRPC, paying for washing of Muzuli PS case number 08-2023 under section 324 IPC, arising out of GR case number 9 and in connection with GR case number 981-2022, along with the charge sheet number 13-2023, dated 3/5/2023, and subsequent proceedings thereto. It is submitted by the learning council for the petitioner. That what? Who is the accused? Number 1 or 2?
Number 1 is accused.
That the accused petitioner number 1 and the victim petitioner number 2 are the good friends, and they used to they resided in the same rented premises. On the day of incident. 23. But it is, what's the probate matter?
Lordship is a challenge to the succession certificate granted by.
Succession certificate.
Yes, Lordship.
We have not issued any. Respondents were already appeared.
Actually,
1 to 4.
Lordship, the AD card have written against them. And
They
they,
also entered into appearance, I think, or no?
no, they haven't. Actually, Lordship, opportunity on the last occasion, opportunity was given to them to appear. So they did not appear, so this matter has been listed for disposal. Here you go.
What was the interim order?
Lordship, the stay of operation of the certificates, Lordship.
The state.
Yes, it was stay. Lordship, these notices were issued, received last year, Lordship.
Yes, that is January.
It is not there.
Yes.
If I may, Lordship. Lordship, this,
What was the I stands for?
pardon, Lordship.
I was what? for
I was for stay of.
what?
the
For stay, that was
proceedings.
already.
That was granted, Lordship. Lordship, by this appeal, the judgment and order dated 13/4/2023, first passed by the learned district judge Bomdila, is being challenged, whereby succession application was issued, and in the succession application, the petitioner was given 50% of the debt and securities of the deceased, and petitioner number 2 and respondent number 2 and 3 were given 25% each. Now, Lordship,
Petition number, petitioner was given 50%.
50% of the debt and securities.
Now, here you are the petitioner.
Herein I am the petitioner. Herein I am the petitioner.
That means you were given 50%.
I was given
You
50%.
were given 50% and the
Yes.
respondent number 2 and 1 and 2 were given 25.
2 and 3. 1 was not given anything.
On number 2 and 3.
2 and 3.
2 and 3 given 25.
25%.
That is when 50% were given to the respondent number 2 and 3.
Yes. I was the applicant in the succession application before the learned district judge.
Oh, you were the applicant.
I was the applicant. Now
So
the-
who were you?
I am
You
the
are the-
brother
you-
of the deceased.
You are the brother of the deceased.
Yes, Lordship.
And he was unmarried.
She was unmarried, Lordship.
She was unmarried.
Yes.
Achha.
Lordship, she disappeared. The facts briefly, Lordship, is that she disappeared in the year 2014.
Oh, achha.
So thereafter, after nearly 7 years, an FIR was lodged before the officer in charge Bomdila regarding her missing status, Lordship. Thereon, a civil suit was filed for declaring her dead. That was granted, Lordship. Now, basing on the declaration of civil debt, this succession application was filed, which was registered as succession application number 96 of 2020. Now, in this succession number 96, Lordship, notices were issued to respondent number 1, 2, 3, and 4. Now, the respondent number 1, 2, and 3 are my brothers. Respondent number 4 is the daughter of respondent number 3.
No. You are the brother of
The
so
deceased.
deceased.
Yes.
And 1, 2, 3, and 4 are
1, 2, 3 are also her
your
brothers.
brother.
Yes, brothers.
That,
We are
that
brothers.
means they are the also brother of the deceased.
Yes, Lordship. They are brothers of deceased. And the respondent number 4 is the daughter of the respondent number 3. So she was her auntie, aunt in her relation. Now, Lordship, as notice was issued, respondent number 4 appeared. She objected to the grant of certificate to me. Then respondent number 1 appeared. He said that I have no objection. Now, as respondent number 2 and 3 were not appearing, the court directed that paper publication may be done. That order has been annexed at page number 22, my lord. Then after the paper publication, they did not appear, respondent number 2 and 3. Then white order dated 30/8/2022, ex parte proceedings were initiated against them as they had not appeared after
2 and 3 against 2
against 2 and 3.
Now, after the ex parte proceeding, Lordship, what happened was that this matter was adjudicated as respondent number 4 has contested the case. Now, the learned district judge has opined that respondent number 4 is not entitled because the father is still alive. She cannot claim now. That is it. However, Lordship, what has happened is that the learned district court had given succession certificate in this manner that I was given 50% and my two other brothers who did not appear after against whom ex parte proceeding proceeded, they were given 25% each. Now, my reason for coming before this honorable court is that, my lord, that this being a civil case, my lord, this has proceeded ex parte against them. Now, the purpose of issuing a notice under section 372 of Succession Act is to inform the other parties, Your Honor, my lord, that if they desire, they can object. If they don't desire, they cannot object. They may not object. Now, if supposing, my lord, that like respondent number 1, he received the notice, he came, he said, I have no objection. Then the honorable court did not consider his claim. He was not given any. Now, these two person, 2 and 3, they also remain absent despite of service of notice. One thing may be considered, my lord, that we are family members. Her daughter appeared, they have full knowledge regarding this. But as my lord knows that people don't tend to like to come to courts. They did not come.
But do you think that if it is an ex parte order, the
Yes,
rights of the parties will be waived or such?
We,
Because suppose if a case proceeded ex parte, in
Yes,
that
ma'am.
case also, it may be dismissed.
Yes,
Because
ma'am.
it stands on the merit of the case.
yes, yes, yes.
So
that
do
is
you
it.
think that as because the 2 and 3 did not appear,
Yes,
so
ma'am.
they cannot receive any property, they do not have any right or they cannot possess any right over the property of the deceased?
No, exactly. We won't say, we have taken a stand that they have waived off, but we have also taken a stand that, my lord, that when a party receives a notice, now, my lord, it is generally in succession, if the applicant is given no objection from the other party. Now, they have not appeared, they have not expressed their willingness. If they had wanted, they could have appeared and they could have asked for their share. And even in the appeal also, Lordship, they were given opportunities to appear and contest this case. They have not, because they do not want to. And one issue here being the Lordship, that if this is to be so, my lord, that if respondent number 1's NOC is to be considered, he said that I have no objection if it is given. That was considered, and if the same parameters were considered, then everybody would have been given 25%. But the honorable court, the learned court, decided that okay, he came and he gave his no objection, 50%. But these persons, our contention is that, my lord, that these persons, if they were desiring that their civil right, that they may be allowed some claim, they would have appeared and they would have participated in the trial and claimed for their rights. They did not. So we are saying that they are not interested to pursue and they do not want any claim. That is our first thing. And second, as I'm repeating, my lord, but as if on one hand, the honorable court could consider that a party who had appeared and said we had no objection, that they be given, that their share was given to me, if these people, these 2 persons who have remained absent, and by being absent, they have conveyed their no objection, then we are saying that they have conveyed their no objection by remaining absent. That is why this whole 100% should have been granted to me. That is our limited prayer, Lordship.
I can pass the order and pass the order within next week. So let it be remain as the CAV for the time being. I'll try to pass it.
Much obliged.
Hard Mr. So-and-so, order reserved.
Much obliged.
Make it CAV. 20.
Lordship, this is a joint application. Lordship, I'll be very brief, Lordship. Dispute arose out of a small petty issue, Lordship. He was traveling on the road. Some excavations, art cutting was going on. Lordship. And I have signaled the driver of the excavator to stop for a while I was passing with my family. And he did not listen actually. And then some sand and stone fell into my car, thereby some damages was caused. So out of frustration, since my children was also traveling with me, since I was fearing for their life, and then I came out from the car and there was a small scuffle between the driver and the this alleged accused. Now matter is pending before the Judicial Magistrate First Class. Now charge also has been framed. As per record, I find that charge has also been framed, Your Worship, under 326 IPC, Lordship.
Under
326, Lordship. Initially, the sections FIR was filed with Lordship will find at page 18, Lordship. Initially, section 341 and 323 was charged against me, Lordship. Page 18, Lordship, Annexure 1. This is the FIR.
But subsequently, charge sheet was filed under.
Charge sheet was filed under 324.
324?
324.
And the charge frame under section 326?
326, Lordship. Now, mutual settlement is at page 33, Lordship. They have settled the matter. Proceed. Petitioner number 1, he is the alleged accused. Petitioner number 2 is the victim. And petitioner number 3 is the informant, Lordship. Now, informant, he is the caretaker of that excavator, Lordship, who was looking after the work that was carried out. And Lordship, injury report will be there in the NCR, Lordship. That was not provided to me, so I could not annex in my record, Lordship. Bruises and I've seen it, Lordship. Bruises and fracture was caused to him, Lordship, since he was attacked by blunt side of the dowel. Bruises and fracture was caused, Lordship, as per the MLC, Lordship, medical report. Settled the matter, Lord. I have, Lordship is aware about there are catenas of judgment, Lordship. Now this Ram Gopal and others versus state of Madhya Pradesh, Lordship. Entire Lakshmi Narayan as well as recent judgment, Lordship. Entire judgments, Gyan Singh, Narendra Singh, all has been dealt, Lordship. Here also, Lordship, regarding 326, that has been quashed and set aside. Here, in fact, he was convicted and the matter was settled and his punishment was quashed and set
In the
aside.
appellate state.
Lordship.
In the appellate state.
Lordship. Here, in fact, his finger, one of the finger of the alleged, of the victim was chopped off, Lordship. Relying on this very judgment, our own High Court, Lordship, Honorable Court, in Sorang Tanya case, Lordship. Here also, Lordship, the injury caused was small little finger of the alleged victim was chopped off, Lordship. Here also, Lordship, this Honorable Court has interfered, Lordship, relying on this judgment of Ram Gopal and others, Lordship. So my humble prayer is to, it's a fit case for set aside, of course.
Yes, Your Lordship. Lordship has already seen that in the judgment given in the Supreme Court, it was on the appellant stage, and the case was not quashed per se. Only the conviction was lessened to certain point, Your Lordship. Now, if I may take Your Lordship to the FIR, Your Lordship, I'll be relying on many of the small points where Your Lordship will have to observe as such, because these are, since for quashing under 482, Your Lordship, it's for sparingly and cautiously, how it has to be cautious. If I may take Your Lordship to page number 18 of the FIR, Your Lordship. Petition. Lordship will see the date of the FIR is 14 September 2016, Your Lordship. Down below, Your Lordship will see the complainant. His address and his position is the site in charge. He was the site in charge. Now, if Your Lordship will see the signature of the complainant, Your Lordship. Now, if I may take Your Lordship to page number 16, Your Lordship.
Page number
16. Your Lordship will come to, this is the same person, that is the complainant, Your Lordship. Now, if Your Lordship will come to page number 17, Your Lordship. Your Lordship will see the signature is totally different to the signature of the complainant. The very next page is the FIR, Your Lordship. Totally different.
Here, which is it?
Techi Sanya.
Huh?
Techi Sanya, who is the complainant, Your Lordship.
Here, where you have.
Your Lordship will see.
Petition is page number 16, the signature is
It's 17
page number 17
of the affidavit, Your Lordship.
affidavit.
Yes. Page number 17, Your Lordship will see in the signature of the deponent.
Here it is one signature. I don't know why in deponent column there is a one signature. You will find, I find one signature.
Yes, yes. What I'm trying to convey, Your Lordship, is that the signature
Yes, yes.
is of the same person,
Yes,
totally
yes,
different. Now, if Your Lordship, I have also flag marked, then Your Lordship will come to page number 36. It's page number 36, Your Lordship. Your Lordship will see yes, sign of Techi Sania, Your Lordship. Your Lordship will see the signature. It's also completely different. May I proceed? Oh.
Here, acha,
Lordship and seen, Your Lordship.
yes, yes.
Now, in this agreement, the complainant is not a party, Your Lordship. He has signed, though he has made his sign, Your Lordship, he is not a party to the settlement, Your Lordship.
It's not a party to the settlement.
Yes, he has just put his signature. The only settlement is between, deed of settlement is between Rajendra Adab and Tadar Hagia. Rajendra Adab is the person who, victim, Your Lordship. Now, if I may also take Your Lordship to Tadar, signature of Tadar Hagia, Your Lordship, we'll see at page number 36, second party. Now, if I may request Your Lordship to take up the LCR, Your Lordship.
Dasti Sania is the complainant and Prosper is his Rajendra Adab
A
is the
victim.
victim.
Yes, and Tadar Hagia is also the accused.
Hmm.
I'm just trying to show the variation in the signature, which, as per my, it need to be cautiously taken into consideration, Your Lordship. Now, if I may, I have also flagged mark, Your Lordship will see the bail bond that he has signed, Your Lordship. Above is the signature of Tadar Hagia, Your Lordship, which is completely different to the signature in the settlement, Your Lordship. Now, Your Lordship will see that this settlement at page number 33 was done on 26 September 2023, Your Lordship. Six years after the charge sheet was filed. Charge sheet was filed in the year 2016, Your Lordship. Now, my concern here is that, Your Lordship is well aware that if there is an excavator driver for a certain project, Your Lordship, after the completion of project, it's not specific if they are still an employee of that same firm, Your Lordship, because in the work started in the year 2016, Your Lordship, and therefore my apprehension that these are not the genuine signatory of the settlement deed, Your Lordship. Now, my second leg of contention is that, Your Lordship, Lakshmi Narayan clearly says that timing of the settlement is very important while considering 482, Your Lordship. FIR was in the year 2016, Your Lordship. Charge sheet was filed in the year 2016, Your Lordship. Till date, the prosecution witnesses has also not turned up. The trial has not started yet, Your Lordship. Subsequently, in the year that is the last of 2023, the settlement was done, Your Lordship. And immediately thereafter, in the November, this petition was filed. Secondly, the nature and gravity of the offense, Your Lordship. 326, the maximum punishment is life imprisonment, and the minimum punishment is for 10 years, Your Lordship. It's very clear in Narendra Singh where it says that for heinous and serious crime, they cannot, the court should not normally quash this under 482, Your Lordship. Now, in this case, Your Lordship will see, will Your Lordship, consider this as a private wrong or public wrong is also to be considered. Though it is an injury to an individual person, Your Lordship, what was he doing at that point of time? It was for the construction of a highway, Your Lordship. Public disturbance to a public person who was under the process of his service for the construction of public highway, Your Lordship. Only because he was not given, during his excavation work, some of the mud fell in his car. This person comes out with dowel. There are other witnesses also who have seen it. Comes with the dowel and directly hit the excavator person without any provocation, Your Lordship. That also to be taken into consideration, Your Lordship. At this instance, Your Lordship, taking into consideration all the aspect given in Narendra Singh, Lakshmi Narayan, that nature, the section under which he has been charged is of grievous nature, the timing of the settlement, Your Lordship. Also the signatory that I have pointed out, Your Lordship, cautiously, if we are taking those in settlement into consideration, Your Lordship, those are still in, seems to be under disputed observation, Your Lordship.
Lordship, regarding the settlement and the affidavit that has been shown, Lordship, that Lordship will see that he has been, all those settlement as well as the affidavit that has been shown before the notary public, Lordship. Normally, the notary public, if the matter is shown before the notary public, it has to be a genuine documents that has to be seen, Lordship. Maybe there must be a bit slight difference in the mode that the signature has been done, Lordship. But then Lordship has to see that it has been done before the notary public, Lordship, who is authorized to take on oath, Lordship. And then regarding the settlement agreement, Lordship will clearly see that the informant, he is also the signatories of the settlement agreement, Lordship. Lordship has seen as the learned PP has already shown, Lordship, that he has put his signature, Lordship. Clearly, he has put his signature, Lordship. And then the two judgment that I placed, Lordship. Lordship will see that those judgments, especially that Ram Gopal, Lordship, that the settlement was taken place after the conviction only, Lordship. Whether the stage, at this stage, can this matter be quashed? That is the question before your Lordship. I think this is a pit case, Lordship. Only the charge has been framed, Lordship. Trial is to be begun, Lordship. And Lordship has seen in the cattiness of judgment, Lordship. Lordship can interfere, Lordship, under section 482. If this honorable court sees that it will be an abuse of the process of the court, Lordship, and for the interest of the justice, Lordship. Now, if the proceeding is carried out, Lordship, if proceeded, Lordship will see that it will be a futile exercise, Lordship. It will be a wastage of the valuable time of the honorable court, Lordship. So it's a pit case, Lordship. Lordship can interfere, Lordship. That's all.
Your
And
Lordship,
then
only with regard to
regarding the incident that has occurred, Lordship will see that FIR as well as the statement of all the accused witnesses as well as the victim as well as the alleged accused, Lordship. Lordship will see that the incident occurred out of sudden thing, Lordship. Since he was crossing the road, Lordship, that incident must also has to be seen, Lordship. He is the father of the kids. They were traveling with him, Lordship. Suddenly, he has waved his hand and he has stopped him from excavating so that he could pass safely. But unfortunately, some stone or some sands fell onto the car. So suddenly, out of anger, he went and scuffle took place and some injury was caused. And Lordship will see also the injury report is with the record, in the record, Lordship. It says a fracture and then bruises was caused, Lordship. It's of serious nature.
Your Lordship, only with regard to that point where he's stating that relying on the Supreme Court judge, Your Lordship. Your Lordship will, there is a slight difference when a compromise after conviction and compromise during the trial, Your Lordship. after conviction, there is no the ground that has been given, Your Lordship, for 482 for the abuse of the court and other grounds, Your Lordship, that does not apply in appellate stage. Appellate stage, or Your Lordship will also see the conviction is not forgiven. His punishments are lessened. Whatever time he has spent in the jail, that is also only been considered, Your Lordship. Otherwise, Your Lordship. And in another judgment that of our own High Court, Your Lordship, Justice B.J. Soikia's judgment, even in that case, Your Lordship is aware that 482 with different facts and circumstances of each of the case. As far as I've gone through the judgment, Your Lordship, the facts of that case has not properly been reflected in the order, and therefore I could not. The section is 326. When in his hand was stopped, there's a sentence, Your Lordship. However, certain facts I'm not aware of that. Therefore, I won't be commenting anything on that behalf, that judgment.
Maybe I don't have any time most probably today to pass the order.
Anything, Your Lordship.
So let it be on CV and here it till next week. I'll try my best
Yes.
to give all the judgment within
Yes, yes,
under seal.
Deep.
Lordship is passing the order this week, Lordship.
I'm trying.
Lordship, otherwise, in the month of February, trial will be for this case.
Almost.
Lordship. Since there is no stay.
Trial was not commencing up till 7 years, so what will we have?
That's why, Lordship, I have not pressed for the interim in the initial stage, Lordship.
Okay. Miss Lakshmi, what had happened to her?
We have not, she has not informed, she had just informed that she won't be coming to the court. But then as per what she had informed to the PO, it seems she had fractured her leg, Your Lordship.
Fractured her?
I'm not sure because the PO has stated that Lakshmi madam ka bandage, पैर में bandage बांधा हुआ है. That's what we were informed, Your Lordship. Yesterday she said she won't be coming, only in message. We thought for some personal difficulties, and we thought that she might, yes.
And what about Mr. Seri? He is on
Mr. Yes, Mr. Singh is also has been caught up in his family issues, Your Lordship.